is Tuesday, February 10th. Apologies for the very slight delay, our 1 p.m. bill hearing. With that said, for those who may be new to the committee, I'm the new incoming chair, Delegate Valderrama, Vice Chair Charkoudian, who is not here right now. I just want to preface by reminding everyone, except for the legislators, everyone here who will be testifying has 2 minutes. You will be timed. We respectfully request that those that follow after one another that you not repeat what has already been said, but highlight what you would like to say. We try to ask that you not read from a script. We understand that sometimes you want to cover every issue, but we understand. And for those who have submitted written testimony, members do take the time to read your testimony, so please know that you are read. I will also preface by saying, for those who aren't familiar with my style, if I tend to stand, it's not out of disrespect. It's just not healthy to be sitting here for 2 hours on a time, and I'm sure you can understand that. But know that I am listening, the vice chairs and all the members are listening. We also ask that you be respectful of the members and you. You are here to testify before us, and we are here to listen. So with that said, we have a total of, and I just read it, forgive me. Yeah, so we have, well, I want to say we have a total of 57 in-person witnesses, so time is of the essence that you express what you would like to say. With that said, we will begin with House Bill 152. Delegate Stewart, if you would like to bring your panel up with you.
For the record, my name is Vaughn Stewart. This is House Bill 152. First, just want to say great to be back here in the committee. I know I've already been here a few times. I'll be here a few more times. If you like that, great, you're welcome. If you don't like that, just know that Delegate Ahrens is the one who told me to submit as many bills as possible in ECM because he likes my testimony. So I know he's not here right now, but you can. Yeah, you can thank him when he comes back for the Stewart show day after day. So this bill, this committee already passed. So I'm actually going to be relatively brief. This bill is about elder fraud. Y'all probably remember it from last year. A number of you voted for it. It passed on a bipartisan basis in the full House, and then it languished in the Senate. But as a little bit of a reminder, if you send an electronic transfer of essentially if a hacker or a scammer hacks into your account and sends some kind of electronic funds transfer to someone else and steals your money, you have recourse under a federal law called the Electronic Funds Transfer Act for checking account fraud, for credit card fraud, for Venmo fraud, all sorts of. If you send a wire abroad, you have consumer protections in place that basically cap the consumer's liability and put some liability on the bank. The reason that we like to cap the consumer's liability for these types of frauds is because we want to give the banks some skin in the game so that they put some stronger consumer protections and safety protections up front to try to prevent these frauds from happening in the first place. However, the reason the bill is here is that there is one singular type of consumer transaction, electronic funds transaction, that some banks have said doesn't count, is not included in this federal law, and that is the wire transfer, specifically the domestic wire transfer. And so if you send a wire transfer, you are actually responsible for the entirety of the loss, or rather whether it's scam involved or not. So if, for example, a scammer breaks into your bank account or steals your password and sends a $30,000 wire domestically to someone else, you don't get any of the same protections, and in all likelihood, you can not recover the funds from the scammer, and the bank is not responsible for any of the funds. So this bill fixes that. It puts every single electronic funds transfer on the same playing field. The reason that wire transfers were exempted is because in the 70s, when this law was passed by Congress, wire transfers were actually not normally used by consumers. They were business to business, sophisticated business to sophisticated business type transfers. It's only recently that consumers started to use wires for things like buying homes and for other reasons. And so that's why some banks have historically concluded that those types of transfers are exempted. There's active litigation on this topic, which is to say that the CFPB had previously concluded, and a number of other different involved entities had concluded that wire transfers actually should not be exempted. And so while that litigation goes forward, what the bill essentially asks you to do is to go ahead and protect seniors in Maryland today. Now, my very, very good friend, Robert Enton, will come up next, and he will tell you that this is unprecedented, that it will make the sky fall right on top of our head, and that we are trying to become the first state in the country to do this appalling thing that is going to hurt banks, and it's going to cause them not to do wire transfers, and it's going to be really terrible. I love Bob, and he knows that, but on this issue, unfortunately, he is incorrect. A number of banks in the aftermath of that New York court case have already adopted the posture that wire transfers are included in EFTA, because that's what the court case said. And so they have already started to take the kind of safety protocols that we want them to see if this bill was passed. So in other words, banks, especially within the Second Circuit, have already started to put these safety protocols in place, which help retirees, help people who have been scammed, and have not caused any sort of malicious or deleterious effects on the lending market or the banking system up in New York or in Connecticut. So it's not going to cause the sky to fall. You already passed it before. It helps seniors. Please pass the bill. Thanks.
Hello. Thank you to the committee, and thank you for Delegate Stewart to allowing us to testify on this important bill. My name is William Steinwittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau. We testify in strong support of this bill. According to the U.S. Census, 17.3% of the state's population will be over 65, is over 65 years of age. So it is very critical for us to protect seniors. Nearly $28.3 billion is lost through the exploitation of seniors every year. I just wanted to talk briefly about a couple of clients that have faced this issue. MLA represented a senior client whose sister was instructed to transfer thousands of dollars each month to an unknown account. When the brother heard about that, our client, he then provided his sister with money to help her falling into financial destitution. What happened, though, however, was that caused him to fall behind on his mortgage and have to file a bankruptcy, a very expensive one. He was in bankruptcy for 5 years. We were able to save the house, but it took a lot of efforts. Because his home had equity, he also had to pay other creditors, such as credit cards and medical debt. In addition, we also represented a person came to one of our outreach clinics who gave millions of dollars to a scam to a person that was posing as a love interest in China. This is becoming an increasingly big issue. Is that overseas they are sending emails randomly, and sometimes people answer them, and they give away a lot of money. And Delegate Stewart's bill will help to prevent this from happening. So for those reasons, Maryland Legal Aid testifies in strong support of House Bill 152. Thank you.
Good afternoon, Chair, members of the committee. For the record, my name is Marceline White. I'm the Executive Director of Economic Action Maryland Fund, and we are here in strong support of House Bill 152. I just want to make a couple points. This bill is critically important because it builds on all the good work that this committee and the General Assembly have done over the past few years to protect elder adults. We think this is an important issue. Our Securing Older Adult Resources program, SOAR, educates 900 older adults a year and helps them with tax benefits and tax assistance. We educate them around digital privacy and consumer scams. And while that may seem simple, as technology changes, it becomes more and more difficult to keep up with the kinds of consumer scams we're seeing. So things like AI and deep fakes, where it can mimic a grandchild's voice, are increasingly the kinds of things we see our older adults contending with and losing money from. What this bill does is it will allow our older adults to have the same kinds of protections as they do with other kinds of consumer scams, where just in this case through electronic fund transfer, which is increasingly becoming endemic and something that is one of the frauds we're seeing. The FTC said Americans lost $343.7 million on wire fraud transfer alone in 2023. So we think this bill is timely, important, and we urge strong support for HB 152. Thank you.
Thank you. We'll start with Delegate Pippi.
Thank you, Madam Chair. Delegate, good to see you. I want to say I asked this last year, and there was some back and forth, so it's more of a clarifying point, and I'll use the example that you gave. So when you testified just now, you said if somebody snuck in or broke into somebody's account and wired money. So here's my question. Does this bill apply if someone took in login credentials, someone other than the person who's the owner of the account? Someone gets these login credentials and then wires money in someone else's account for fraudulent purposes or whatever. That's scenario A. Scenario B is you have an elderly person who logs into, let's say, her own account and then sends the money inadvertently to the wrong place. So what I want to understand is which scenario does this bill cover? Does it, you guys with me?
Yep,
Okay.
absolutely.
Okay.
So first of all, Delegate Pippi, I want to commend you because this is very similar to the question you asked last year, and you really delved into the details last year on this issue and helped us come to an understanding on the committee of a very technical and complicated issue, and then you ended up voting for it, which I appreciate because we finally got to the bottom of this, which is that the bill is way more narrow than I think a lot of folks would like to see. And here's the distinction, and this is just under EFTA and federal law. Under EFTA, the only time consumers get any of these protections in terms of capping their liability and putting something on the bank and giving banks skin in the game, the only time under federal law that this is the case is when the transaction is unauthorized. Unauthorized. And courts have defined unauthorized to basically mean who pushed the button. So if you don't remember anything else from the committee, just remember it's all about who pushes the button. So in scenario A, where a scammer has hacked into my account, has somehow gotten my password, even if they tricked me into giving their password because they say that my grandchild needs money, give me your password or whatever. If the scammer is the one who pushes the button to say submit wire, then that's in the bill. That's unauthorized.
So that's what this bill would protect against.
Exactly. But
so
a scenario,
if grandma pushes, or grandpa pushes the button, this bill does not apply to them.
Correct. Even if they're duped, if they sent it to the wrong address, if they did it on purpose, if someone called them and say, hey, I need you to log into your own account and send me money, that's actually under federal law an authorized transfer, and neither this bill nor federal law helps those people at all. And so the discussion that we had, and I think that you even had with the chair last year, if my memory serves, is like, a lot of people think that probably we should help people who are duped and then press the button themselves, but federal law is just very, very limited. So all this bill does is for unauthorized transfers where people did not push the button, it applies the same protections that apply to every other type of transaction you could possibly imagine, but exempted wires. And the only reason we exempted wires is because in the 70s, consumers didn't do wires.
So
and now they do.
Last thing I'll say, and this is just for the good of the order. So if somebody hacked into my bank account,
Yeah.
and wired the entire balance of my bank account to somebody else without my knowledge, that money's just gone.
It's gone. You have basically no recourse.
Okay, all right, thank you.
Yep, thanks.
Delegate Weivel.
Thank you, Madam Chair. Just recalling as well the discussion from last year, it was felt that this would, because we're Maryland, we can only regulate state banks. And I know you have this out clause in here that if it's found unconstitutional or something, it no longer applies. Does it no longer apply, period, or it no longer applies to all banks, state and federal?
Right. So if you guys remember this discussion, and by the way, Delegate Weibel, I won't thank you because you voted against the bill. But I'm kidding. I appreciate your scrutiny.
There's
of
a
this.
reason you're back here.
That's right. That's right. So no, but I do appreciate your scrutiny of this constitutional issue because my view of this, and we got an AG letter to this effect, is that this bill is very, very constitutional and that we can tell even federally chartered as well as state chartered banks what to do in our own state laws, as we do on a number of other different things. So my view is very much that it's constitutional. That said, in response to the feedback from Delegate Weibel and other members of the committee in past years, and this is how we got it out last year, is that we added this, essentially this kill clause to the end of the bill that says if any court ever finds that any part of this bill is unconstitutional, then it self-destructs. It's as if the bill never passed as it relates to every bank. And if you guys remember the discussion on this, it was that Mr. Inton and others made, I think, a very valid point, which is that we don't want to pass a bill that only applies to our state charter banks and puts them at a competitive disadvantage with respect to the big guys. And I certainly don't want to do that. So that's why we added this provision in there, and we've had the AG and we've had lawyers look at it. It's fine. It's constitutional. Mr. Inton will probably tell you that he's never seen it before, a clause like that before or whatever. I think that's what he said last year. Again, I love Bob. He's great. But he fights very hard for his clients. He can put that in his next pitch. But that clause is fine, and to answer your question, it protects all banks. So if any court ever says this bill is unconstitutional, it self-destructs, and it's as if we never passed it at all.
Okay. All right. My last question. I heard you just say that this applies only if someone else hacks the account.
Unauthorized.
But the gentleman from Legal Aid brought up this love interest scenario where someone wired money to someone who was fraudulently in China or wherever. It sounds to me like that scenario, someone was wiring money to someone who duped them, and you just said that wouldn't help them. So
yeah, so I don't exactly, I don't exactly know this fact pattern, but just to be crystal clear, if a love interest dupes you, but you still press the button, like if the love interest is like, oh, Vaughn, like you're amazing, like please send this money to South Africa or whatever, which happens a lot.
I was going to say, do you get this?
It happens a lot.
Yeah.
But they're all vetted. They're all vetted. These are all legitimate. As it relates to me, I've vetted this very, very hard. They're all legitimate emails. But if they dupe me into pressing the button, and I send them a wire, and they dupe me, and I press the button, and I'm like, oh yeah, you're right, I am the most amazing and attractive delegate, then I'm out of luck under the status quo and under the bill. But if my love interest whispers sweet nothings into my ear and says, give me your password, and then they press the button, this bill would help me.
Okay, so what scenario, sir, were you referring to?
We were just speaking generally about the fraud that we see. We couldn't say specifically if that would have been prevented in this case, but just generally that we see this happen a lot. And even if if this bill eliminates some of it, it's still a step in the right direction.
All right, it just sound like your example you used wouldn't apply in this situation.
It's very possible it may not.
Okay, all right, thank you.
If nothing else, Delegate Stewart, we love having you here for comical theater.
Thank you.
With that said, I see no, Delegate Queen.
Thank you, Madam Chair. I'm going to have to move my thing over so you can see it. So thank you for the bill again. Just to get on the record, is this bill amended as it was last year?
It is. It's identical to the bill that the committee passed last year.
The amended bill the committee passed last year.
That's right. And I think it passed 117 to 27 or something like that on the full floor, the full House.
Thank you.
Delegate Ahrens.
Good afternoon.
Just my smile brings out. See, I told you, he's the one who put me up to putting all these ECM bills out.
Yes, I did. I just appreciate you being here. I guess going back to this love interest, and I don't want to dwell into Mr. Weibel's personal life here, but how do you know who hit the button?
Yeah, that's a good question. So normally if someone sued, if someone basically like said, not even sued, just went to the bank, here's how it would work in practice, right? Let's say the love interest woos me and I actually do press the button and I reach out to the bank and maybe I lie, right? So I say like, maybe I'm sophisticated in how the law works, which normally people are not, but let's say I lie and I say, actually, no, my love interest is the one who pushed the button. Well, the bank is going to be able to look at the IP address for the person who clicked the button, and if that person was in my home, then they're going to say, we're rejecting your fraud claim because unless your love interest was not in your own house, you were in your house, you pressed the button. But if the IP address on the button click was in South Africa, for example, then it's possible that I'd be okay.
Okay. I mean, I hear what you're saying, but I sit back and say, if that love interest, say they had all that information and we were talking about it, they were talking about it beforehand, and they went through everything, and then later that night, that love interest goes back in and hits that button, it still has the same IP address, you're saying there's no help.
So generally, there have been situations where there's identity theft violations that do occur in someone's own house. So for example, like without someone's knowledge, like their own child could essentially press the button for them and wire money somewhere, for example. And those are really thorny issues. And banks generally err on the side of rejecting fraud claims when someone is in their own house because they assume that maybe the person who's been duped is actually in on it with a family member. It can be really messy to prove in that situation. So I guess the takeaway for the committee is that we don't want to get that far. We think that if this bill passes and applies to wires, that banks, as they have elsewhere, including in the Second Circuit, will put the kind of safety protections up front so that we have way fewer of these situations in the first place.
Okay. Last thing, on this, it's still in the courts.
Yeah, so up there, it's been appealed to the Second Circuit, it's still in the courts, but no matter how that goes up there, it's not necessarily going to help us anytime soon because we're not in that zone. So my pitch to the committee is not, let's wait and see how the courts resolve this. My pitch has always been, regardless of what they say up there, we should go ahead and take action to protect Maryland seniors and scam victims here now, either way.
And I would agree with that, except that if it's this big a deal, if it's that important, we would expect, this is a year now since we dealt with this in the past. It's still held up in the courts. And one of the other things is, honestly, and you said you did it for protection, was I haven't seen many bills saying that if this thing is challenged in court, it's automatically dead. To me, there must be some question as to the validity of this, that it may not pass. And I would probably not support it based on the fact that we're going to go through all this stuff right now to put legislation in, actually enact it, only to have it, well, by the way, if it doesn't work, it's going to go on. And I'm just not comfortable with the scenario, but I do appreciate you bringing a bill.
I appreciate that very much, Delegate Aronson. If you want me to, I can absolutely share the AG opinions that I've gathered. I think we're on very, very firm footing, and the only reason you see that self-destruct clause is because we're just taking a boot and suspenders approach, or belt and suspenders approach to this, not because I think that it's going to be struck down. I just really, really want to make sure the committee feels good that we're not going to harm our state charter banks. That's why I threw that in there.
Right. And I appreciate you coming in. You're one of the few people that bring a bill here that I sometimes disagree with. I feel so much better about myself when you're done. Thank you.
I'm going to add that to my highlight reel. Thanks. Appreciate it.
Delegate Rose.
Thank you, Madam Chair. So one thing I had a question on, so when you were saying that if the person's IP address is traced to their home, but is it not true? I mean, IP address is a foreign actor. Someone could make it look like they're in that home and they're not in that home. So what is your...
You can. I mean, the way it works right now basically is that if someone is defrauded, they have to inform the bank. Actually, under existing federal law, you have to give the bank notice. And if you don't give banks notice soon, then you actually waive your protections. So if you wait to report, so just kind of like a good note for your constituents who may be going through this, the first thing they should always do is report it to the bank and maybe even to the police or the FTC or whatever right away. Don't wait, because if you wait too long, you actually waive all of your existing rights, either under the bill or a current law. So what people normally do is they submit a claim to the bank, and then the bank does their own thorough investigation of whether it was fraud, authorized fraud, unauthorized fraud, or maybe not fraud at all. And they use a bunch of different things. So IP address is just one of those things. They have sophisticated tools at their disposal. They can look at the device. They also look at other external documents that you might send them to try to prove the fraud. And they do a big review of this. Then they make their determination. And they either say yes fraud or no fraud, and the bank makes that call. And then the consumer has the ability, depending on the kind of transfer it is, or whether we're talking about state or federal law, to possibly file a lawsuit to challenge a determination that they believe was an error. So, for example, a scenario is, I heard about a woman, for example, who someone broke into her account. She's 89. She lives in Montgomery Village in Montgomery County. She's 89. Someone hacked into her account and bought soccer tickets for like some big soccer game that was having in like the Meadowlands, like the place where the Giants and the Jets play. And it was between like Brazil and Argentina. I'm not a soccer guy, so I don't even remember the countries, but they were really expensive tickets. They were like $5,000 each or something like that. And she was on like a super fixed income. And so this one purchase really sent her into this tailspin, and she appealed it to the bank. And they said, based on SeatGeek's data that they sent over and yada, 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 we think actually you bought this. And she was like beside herself. She's like, I've never even been to New Jersey. Like, I don't even watch soccer. Like, I can barely even get out of my house. Like, this is clearly not me. So she tried to appeal to them and send all this other extra documentations, but they held firm and they said, no, based on what our internal analysis is, we think that you, ma'am, bought the tickets. Sorry. So she had to sue, and then they ultimately settled the lawsuit.
So, okay, I appreciate that, but so,
So I guess to answer your question, yes, you're right that there are all kinds of sophisticated tools that exist to allow people to spoof IPs, and you can use VPNs and all sorts of stuff. But IP addresses are not the only thing that banks use. But also, this bill doesn't really change that process at all. Like, the bank is going to make its own determination either way. We're not really putting our finger into that situation. All we're saying is that right now, if you send a wire to Argentina, and it's not, or someone scams you and hacks you in an account and sends a wire to Argentina, a foreign wire transfer, you get consumer protections. But if you send it to Alabama, you don't. And we're just trying to close that loophole. We're not changing anything about the bank review process.
I guess my point is that someone that sophisticated could make it look like it was Alabama and not.
Maybe, but that's currently just the
Argentina.
case for everything. We're not really changing that entire regime. Yes, absolutely, and banks have to invest a lot of money into trying to make it seem like, trying to do a real thorough evaluation of the situation. We're not really changing how that process works. We're just saying that wires should get the same protection that every other kind of transfer does.
All right, thanks for the answers.
Thank you. See no further questions. Thank you very much, Delegate Stewart.
you.
We will now move on to the opposition. We have Delegate Von Stewart's best friend, Robert D. Enton, and Evan Richards.
And people ask me why I'm still doing this at my age. So, good afternoon, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. This is the third or fourth year this bill's been in front of the committee. It did pass out last year. We're very, very, very much opposed to this bill. No state, not one state in the entire country has enacted this legislation. Not one. Number two, there is a pending court case in New York. I have a copy of the brief in that case filed by members of the banking industry and those who process deposits and checks. That case is still pending. This is not the law anywhere. Now, it is part of the Uniform Commercial Code. Uniform UCC bills go to this committee. But it's called the Uniform Commercial Code for a reason. And that's because the idea is that we're going to pass pretty much uniform laws that will go into effect around the country. So we've got Uniform Commercial Code goes from Title I to, I don't know, Title 12, 13. Those bills come to your committee. Those bills pass. This bill right now under current law is we believe, firmly preempted at the federal level. In addition, our concern that we've raised in the past is we believe this bill will not apply to national banks. So it's only your community banks in your districts, whether it's Harbor Bank in Baltimore City, whether it's Industrial Bank in Prince George's County, whether it's one of the banks on the Eastern Shore, they're the ones that will be impacted. And in the fiscal note, going back to 2 years ago, it said in the fiscal note from our own Department of Financial Regulation, OFR notes that the bill may place Maryland charter depository institutions at a competitive disadvantage with other state and national banks as those institutions, quote, would not be subject to the bill's requirements. Now, this language, it's in the uncodified section, and I'll wrap up, Madam Chair. In the uncodified section, it says, you know what? You're all going to have to go comply with this law, which has never been the law in Maryland, on October the 1st. And, you know, if later on a court decides that it doesn't apply to the federally chartered banks, then it's null and void. But you're going to have every one of the banks in your districts They're state charter. They're all state charter. Your hometown banks are going to have no choice but to completely redo their systems in order to comply with this bill. If this bill wants to become law, the uniform commissioners, I spoke with their representative the other day, and I know you're going to cut me off, Madam Chair. The other day, his name is Steve Lightis. They are looking at this to see what they can do at the national level to make sure this would apply in some fashion in a fair way to banks all over the country. We would urge you not to pass this bill, please. Thank you.
Madam Chair, if you need me to smack him on the back of the head next time, more than happy to. Evan Richards, Head of Government Community Relations for the Maryland Bankers Association. Mr. Renton took well over 2 minutes, so I'll keep my comments very short, and quite frankly, I'll just be here to answer any questions the committee may have. Thank you.
Delegate Pippy.
I should have asked this before. So why is there a federal protection but not a domestic one?
I'm sorry, say that again?
Why is there a federal protection for this scenario? Like if you unauthorized wire gets sent to the Bahamas, but there's not one domestically, what is, can someone answer that? I should ask the sponsor.
No, I have to say, I'm not sure what's happened at the federal level. I'm not sure why there hasn't been federal legislation to deal with these issues that you've heard. It's just kind of a little bit out of my sandbox, but I'll be happy to get some information for you, Delegate Pipke, and get back to you with some answers on that. And once again, the only thing I can tell you is that it's going to be a nightmare for banks in Maryland to comply with this law when no one else has it at any level whatsoever.
Okay, thank you.
Delegate Howard.
Thank you, Madam Chair. So you said it's not the law of the land. Has it been introduced into any other states? Has the legislation at least even been introduced?
To my knowledge, once again, no. My understanding is that a consumer conference, that was attended by a member of the Maryland General Assembly, this came up as a point of discussion, something that should be done. And we've had this bill in Maryland. I'm not aware of bills, but I will find out from the American Bankers Association and get back to you.
Okay, thank you.
Are there any other questions? Seeing none, thank you very much.
Thank you for your patience.
Yes, that concludes the bill hearing on House Bill 152. We will now move on to House Bill 103, also Delegate Stewart.
We like your pen. Can I bring up my panel?
Yes, please.
Thank you. I think we may just have one or two people. Oh, yeah, cool. All right, thank you again, Madam Chair. I'm back. This is House Bill 103. My name is Vaughn Stewart. This is also a little bit of a reintroduction of a bill that actually the House and the Senate passed last year, but it goes a little bit further. And this bill actually did not come to you guys last year. It went to judiciary. So this is a kind of a point of first impression for members of the committee. So basically, here's the issue. Maryland passes, the General Assembly passes all kinds of rules to protect consumers all the time. So, for example, we say how long someone has to sue. That's called a statute of limitations. We say what remedies are available to people. So maybe they can get attorney's fees for certain kinds of legal violations, or maybe not. We say they can get punitive damages in some situations, or maybe we say they cannot. We say that people can sue in certain situations. In some situations, we say that people can file for what's called equitable relief, like an injunction. But in certain cases, we say they cannot. We make that decision as the people's elected representatives. So this bill posits a pretty simple idea, which is that consumers should not be able to inadvertently, in basically all cases, unintentionally, unknowingly, in essentially all cases, waive those rights in the fine print of a consumer contract. So last year, we passed, and a number of you voted for, a bipartisan piece of legislation out of the Judiciary Committee and then to the entire House and then out of the Senate, and the governor signed it, which only dealt with the statute of limitations portion of this. It basically said, we create the statute of limitations. Sometimes it's 3 years, 5 years, 1 year, depending on the type of violation. We create that. And so we should not let companies bury into the fine print a shorter statute of limitations than exists in state law. We passed that. This bill goes a little further, and it includes additional rights that consumers might have. Now, I will say, I will very rarely say this, but Bob Enton, Robert D. Enton, who you just heard from, and Grayson Wiggins, and a number of my other friends, they actually had a really good point about how this bill originally came in, which is that it's a lot more vague than I intended. It basically says that consumers can't waive, I think the language is something like substantive rights, and they flagged to me a few days ago when they were submitting testimony, Vaughn, like, what the hell is a substantive right? Like, what are you even talking about here? Like, what do you mean? This is super broad. This is super vague. So I have worked on new language that I've submit to the drafters. I don't have it before you today, but essentially what it does is it lays out exactly the rights we're talking about in an easier to understand way. So I'm actually going to read, I don't like reading things, Madam Chair, which is why I like the ECM rule about not reading. But will read this part, which is that here are the rights that you now, if this bill passes, cannot unintentionally, inadvertently, unknowingly waive in a consumer contract. Number one, limitations period or statute of limitations. We're just kind of put that in that part of the code. 2, damages or monetary remedies authorized by law. So that's like basically if someone tried to put in a contract like, actually, you can't sue us for money. You can sue us, but you can't get any money for it. Can't do that. Number 3, recovery of attorney's fees. So if we say you can get attorney's fees in some law we pass, you can't waive that in a contract that says, by the way, you can sue us, but you can't recover attorney's fees if you win. 4, equitable injunctive relief. So if we allow, for example, a person to sue to basically stop something, to enjoin it, to stop the action, you can't waive that away in a contract. And then finally, a consumer's ability to bring or assert a claim. So in other words, you can't waive in a contract that says, like, by the way, like, you can sue us for harming you physically, but you can't sue us for breach of contract or something like that. You can't do that. So those are, and with the sponsor amendment, it'll just be cabined to those types of issues. And this bill does not apply to sophisticated business-to-business contracts. Businesses should be able to contract with each other because the parties are on an equal playing field as much as they want. But for consumers, they should not be having a choice between basically participating in the market economy and sustaining rights that the legislature passed via statute, especially given the fact that they don't actually read it and they don't even know what's happened until some kind of harm happens and they want to exercise their right. So we basically, as a General Assembly, adopted this kind of approach to the law. That this is the law in a number of other places. We adopted that last year. This bill asks this committee to extend it from just statute of limitations to a few other rights around damages, injunctive relief, and attorney's fees. That's it. And with that, I will ask for her report.
All right. Okay. Good afternoon, Madam Chair and members of the committee. My name is Christine Hines. I'm Senior Policy Director at the National Association of Consumer Advocates. Essentially, NACA advocates for protecting consumer rights in the marketplace. And we support HB 103, and we urge its passage. We support the changes from the last year's law and are grateful that the law was passed and the recognition that consumer contracts are just upside down right now. The one side has all the power over consumer contracts. And there are a couple of points I want to make to follow on to Delegate Stewart. And one is, well, we're in the digital age. I actually am old enough to remember when I used to be able to go in, to walk into, I don't know, Kennedy Center or some other theater and buy a ticket, or call a theater and buy a ticket. But now, or even buy it online, but everything has, buying a ticket right now is a concert ticket, for example. You go through an app and then it comes with a 20-page contract. That's not really what consumers sign up for. You want to buy the ticket, you want to attend the event, and I'm just using that as an example, but it is out of control what companies are doing with these contracts. It's upside down. And so before, in Maryland's law, there are some exemptions in Maryland's law in terms of banning waivers of substantive rights. There are a couple of them. But right now, we really need a bright line rule because these fine print terms and conditions, they come with virtually every product and service, and it's totally out of control. Thank you.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Marceline White, and I'm Executive Director of Economic Action Maryland Fund. We're here in strong support of House Bill 103. Just to make a few points. Again, what this bill does is it supports the will and intent of the General Assembly. The General Assembly makes laws, and what this says essentially is the laws they make concerning consumer protections should be in the contract, and a contract cannot abrogate or change laws that the General Assembly put in place. They cannot make them shorter. They cannot change the tenor of them. They cannot ignore them. And so it really protects the will of the General Assembly in their public interest. Again, we see constantly how confusing contracts are, and they are digital. You know, you click on a button. And at a time when at the federal level, the Consumer Financial Protection Bureau has been rolled back in its enforcement power and its investigatory power, it's more important than ever that Maryland stand up stronger consumer protections. And these really are just codifying what you've already passed and saying the contracts can't change that. So we think this is a really simple, clear bill that built on the work from last session. So for those reasons, we ask for a favorable report for HB 103. Thank you.
Hello, my name is William Steinwittle. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau. I apologize, I was testifying in the House Ways and Means Committee. We testify in strong support of House Bill 103. So one interesting fact that I don't know had been mentioned by the other members of the panel, but over 99% of consumers don't realize that in a lot of the contracts that they sign, there's a required binding arbitration clause, which waives some of their rights to sue, and they're not even aware it's there. So that just shows you how expansive this is. But I wanted to focus on two examples of something that I've seen in my work. I represent a lot of homeowners that are trying to save their home from foreclosure. And one of the biggest ways that you can save your home from foreclosure is a loan modification. And unfortunately, a loan modification is not required by any federal statute. It's totally in the hands of the bank. So basically, when our clients are offered, a lot of times they've offered a loan modification, it's pretty much the only choice that they have. So 2 times, my clients have been offered a loan modification, and they were required, the other side attempted to require that they waive their right to file a future bankruptcy at any point in their lives before accepting the contract. This is a violation of federal law. The state court has no power over the bankruptcy court and its determination of dischargeability or its determination of who a debtor can be. But they tried to do it because they wanted to protect their client's investment, even though it ran counter to federal law. Luckily, we were there to strike those provisions. Had we not been there, however, the homeowners would have faced the unenviable choice of either signing a contract that gave away their federal rights or possibly losing their home. So that is just one example of many that this bill, House Bill 103, will seek to protect. Thank you. And Maryland Legal Aid testifies in strong support of House Bill 103.
Thank you very much. We'll start with Delegate Adams and then Queen.
Thank you, Chair. So someone said bright line, and that's reminiscent of a phrase that I think I've used multiple times as a business owner. You know, we seek bright line, clear paths to compliance with the law in ways that are clear and unambiguous, such that we don't find ourselves in violation of the law. And my concern on a bill like this is if Marceline's right, there's already, laws that are in place, and the purpose of us passing laws is for have businesses to comply. This seems to add just an additional layer of frustration, complexity, use your own adjective for it, but I'm mildly curious why we're even here talking about this bill. If the testimony you're presenting today with your panel is trying to add to or complicate, which is a fairly simple exercise, which is two parties come together under contract to agree to do certain things. I mean, it is a two-way conversation, and I'm just mildly curious why it feels like the second bite at the apple is probably what I'm trying to say to this.
Okay, well, I appreciate that question. I actually thought you were going to ask about how it's a violation of the Consumer Protection Clause if you do this. I thought that's where we were going. That's why I was smiling at you. And we can have that conversation because actually last year's bill did not include that provision in there. So I just want to clarify exactly how this bill is different from last year. So last year, the General Assembly made the decision to say, once the legislature has created a statute of limitations period where you can sue within that period, you cannot waive your right and shorten that period to say 5 minutes, like 15 hours, like 21 days. Like if the legislature set it for 3 years, that's what it is. It's called a statute of limitations.
So can I stop you there? Are you saying that last year's bill did not have enough teeth in your perspective, and this is the bill that gives it some ammunition?
No, last year's bill was good. But
you already, then under law, you've already made it such that the statute of limitations can't be shortened because we've created a bill that did.
Correct. Okay. So this year's bill just extends it to more types of rights. That's it. So
more types of what?
More types of rights. More types of rights. So that's all it is. So last year we did statute of limitations. Now we're going further and saying you can't waive your right to a specific type of damage. You can't waive your right to an injunction. You can't waive your right, all those things I mentioned. You can't waive your right to attorney's fees. All of that stuff would be part of this bill. So it's not a second bite of the apple. We did pass that bill last year. It was good. We're just moving beyond purely statute of limitations and now looking at other rights that the legislature has also passed that should not be waived. And I guess the other thing I would say is I would challenge to some extent the idea that a consumer contract, especially one of these digital ones that you just kind of scroll through and sign, is legitimately a two-way street. I don't think that's really how things work in practice. I wish it was, but I would ask anyone, have you ever successfully been able to alter or amend or negotiate a contract of adhesion with a large company? I've never heard of it. Now, it used to be, I used to hear about cases in like the 80s or 90s where like you go to a doctor's office and they give you some form and you're like, can we tweak this? Can we tweak that? That's a two-way street. What we have now is you have to scroll through a lot of pages and you have to click agree, and there's no negotiation, there's no ability to amend. It's literally a PDF document, and if you try to email the company and say, hey, can we change line 8 on page 4, they're gonna laugh at you if they respond at all. I think that's a one-way street, and I think that's where we're here, which is that we as a General Assembly have passed rules. Now, if we don't like the rules, if we think that we should take attorney's fees out of certain laws, if we think that we should shorten the statute of periods, the legislature, if we think that we should have no punitive damages allowed for this or that statute, that's fine. That's the decision that we should make because we were elected to make those decisions. What this bill stands for, the premise it stands for, is the idea that once we've made that decision, once we've gone through both chambers, and once the governor has signed a bill, and we've made a change to rights, it shouldn't be so easy to have consumers not be able to access them.
So I think I understand better what your bill's doing.
Okay.
But my point remains, businesses, it's frankly no longer a question of if a business falls in violation of some law, it's a matter of when, and the question is it going to be a biggie? So that does get to this consumer protection unfair stuff and trade practice, but that's, I'm not even going to broach that because you and I have done this multiple times, and it is what it is. I'm still worried about the clear path to compliance, because while you're talking about a contract that you sign online, this bill also applies to small businesses that are just entering into contracts for language that's probably 2 paragraphs, but yet how do you know whether those 2 paragraphs doesn't line up here? Now, small businesses don't have legal teams, and I'm just simply saying, I'm not, and I'm going to ask you the question because it goes to my concern about clear path to compliance, is that small businesses don't have legal teams. They're not going to go through and after this bill passes, which probably they should do if this bill passes, which is to spend the thousands of dollars to get the business, to get a lawyer to redraft the documents. You might find at that point, Vaughn, Delegate Stewart, that all of a sudden a little 2-paragraph agreement between 2 parties and a simple small business contract turns into the thing that's that long because an attorney is going to say and now all of a sudden you don't have a simple contract. Now you've got a sophisticated contract. And yes, it complies with Maryland law, but did it really help consumers?
Okay, so
I'm doing
these
that
are
in a way
all
where I'm
very
trying
good
to ask a
points.
question.
Yeah,
but
no, I got it. So this is a very good question. And this is the exact same debate that we had about the bill last year. And you had folks like Mr. Enton and others say, businesses are going to accidentally fall into this trap.
Yeah, that's right.
They're going to be subject to
that's the way to put it.
CPA. And we had that conversation. And ultimately what the legislature, not to pre-compromise or fold my tent too early or anything like that, but the compromise that we made on the statute of limitations provision last year, and this is certainly a conversation the committee could have this year, is the decision we made last year is to strike the CPA part. Mr. N and I actually worked collaboratively last year on that amendment. And what we instead did is to say that the provisions in the law, in the contracts that now are in violation of this new law are just null and void. So in other words, there's no business liability. You see what I'm saying? So businesses don't have to worry about some sort of safe harbor under last year's bill. They're not going to get sued anymore. It just means that if they try to put a provision in there that they can no longer enforce anymore, it's unenforceable.
All right, so let me just ask my last question, and this is narrow, because I heard the testimony at the end here about arbitration clauses. Does this bill invalidate arbitration clauses?
No.
Okay, thank you.
We're preempted under the FAA.
Delegate Queen.
Chair, thank you very much. So I have questions because I agree with you, for the sponsor, agree with you that it is our role as the legislature to make laws and policies. But we have certain committees because of the subject matter, right? So we're not judiciary. So I want to make sure that we're only talking about bill language that are related to us, which is consumer protection. Is that it? So this bill, the intent of this bill is to just put consumer protection rights into a contract. Is that the intent?
Yes, Delegate Queen, it is. I mean, what I will say is, I believe this bill did go to, I could be wrong. Am I wrong about that it went to judiciary last year? Okay, maybe I was wrong, and maybe it never even went to judiciary. But anyway, I would say this is a bill that probably could be credibly sent to multiple committees, but I do think that it most squarely falls under the consumer protection article into your subcommittee that you chair, Madam Chair. So while it does talk about, for example, filing lawsuits, which people would probably consider a little bit more judiciary in nature, I would say that it's firmly within this committee's jurisdiction, and I'm happy to be here.
Okay, so we're going to put consumer protection rights in a contract, which you've already told us are long and confusing. So that helps consumers? I'm not kind of sure how this helps consumers.
So
I'm not a lawyer, so I would be lost.
So consumer rights are not particularly confusing. So what I did say was that I think that the original draft of the bill was quite broad and ambiguous. And I think with the sponsor amendment, it makes a lot clearer what I'm talking about here, which is that for certain types of rights that the legislature has conferred on consumers, we want to make sure that they're ironclad. It's not that complicated. We just want to say for things like damages, things like attorney's fees, things like being able to bring a lawsuit, and things like, as we did last year, statute of limitations, we want to make sure that those rights are meaningful and that consumers cannot inadvertently, unintentionally, or otherwise sign them away in a contract of adhesion with a large player with more bargaining power than them. That's it. It helps consumers because, unfortunately, Delegate Queen, we live in a world where people are harmed by companies. That doesn't mean companies are bad. I'm not villainizing anyone, but sometimes consumers suffer harm from companies. They go to exercise the rights that we as the legislature conferred on them. We deliberated, we debated, we passed them. The governor signed it. There's a right that we gave them. They think that they're able to sue. Sometimes they even file a lawsuit thinking they have the ability to exercise their rights. And then, womp womp, they realize that actually they signed it away on page 18 of a 90-page contract. That's what this bill intends to solve. It absolutely will help consumers. And I think that we can have a conversation, to Delegate Adams' point, about how we can ensure that businesses, especially small businesses, are not unintentionally entangled by the bill's provisions. And I think we had that conversation last year, and I think we had a good product as a result. And I'm just trying to basically reestablish that same conversation.
Okay, thank you.
Thanks.
Are there any other questions for this panel? Seeing none, thank you very much, Delegate Stewart.
Thank you, Madam Chair.
We do
I'm out
have-
of your hair now, sorry.
We do have a virtual favorable, Mr. Jeff Sovereign.
Thank you. My name is Jeff Sovereign, and I am the Michael Milliman Professor of Consumer Protection Law at the University of Maryland, Francis King Carey School of Law. I make my statements in my individual capacity, and I don't represent any organization. I speak in support of HB 103. HB 103 is intended to counteract something you could describe as the law giveth and the contract taketh away. That is to say, for good reasons, this legislature has determined that Maryland consumers deserve certain protections. But businesses often insert incomprehensible terms in their contracts that consumers sign without realizing what they're agreeing to, which frustrates the legislative goal of protecting consumers. HB 103 would prevent that practice by barring small print that eliminates certain consumer rights. We all know that consumers don't read standard form contracts, which makes sense. Studies show that even if consumers read the contracts, they often don't understand them. And even if consumers read and understand the contracts and want a different contract, they're out of luck. Big consumer-facing companies don't negotiate contract terms with consumers. The result is that businesses can write the contracts to suit their own interests. And if that means taking away rights this legislature thinks consumers need, well, that's just too bad. HB 103 would change that, and it would also deal with another problem. Studies show that consumers think if a term is in a contract, they, the consumers, are bound by them, and that enables businesses to benefit from including unenforceable terms in their contracts. HB 103 would deter that conduct. I urge you to vote favorably on HB 103. Thank you.
Thank you, Mr. Sovereign. We do have a question for you, Delegate Roberts.
Thank you, Madam Chair. I guess my question is, so what this legislation looks like, it's barring, are you, this bill is barring long, small print rules or contract, I'm not a lawyer, I'm sorry, but language that would prevent consumers from having rights, or is it barring long, small print altogether?
It's not barring it altogether. It's just barring small print that takes away certain rights that the law gives consumers. And then consumers look at those forms and they see, oh, well, this says I can't sue because I took too long. And they think they're bound by that even when they're not. So the business benefits from putting in the small print, even though it's not enforceable. This law would take that ability away.
So are we talking about any contract, any consumer contract? Because I guess my question is, there's all types of businesses. Does that mean for like real estate? You know, because when I buy a house, I mean, it's incredibly long, small print. Are we talking about that? I mean, or is it certain consumer products? And maybe this should have been for this bill sponsor, but since you work at a law school.
Well, the statute defines consumer contract as a contract involving the sale, lease, or provision of goods or services for personal, family, or household purposes. So those are the kinds of contracts it would apply to.
So is that a purchase of a home? Because that's a household product, I
Well,
guess.
it says sale of goods or services, so yes, I think it would apply to a home because a home is a good, as I understand it.
Okay. Thank you. That's all I have. Thank you.
Thanks.
Thank you, Mr. Sovereign. Are there any other questions for him? I see none. Thank you very much for participating.
Thank you.
We will now move on to the opposition. We have Robert D. Ensign.
Thank you, Madam Chair, members of the committee. Robert Enton, once again, on behalf of the Maryland Bankers Association, but I think every business that we represent would express their opposition to this bill as well. You know, last year, Delegate Stewart had a bill, and we worked on that with him, but it was a very finite bill. It dealt expressly with the statute of limitations. And it said that if you had a statute of limitations, you couldn't, a consumer contract, the consumer couldn't waive it. But that's what it was about. When you read this bill says that you're going to violate the Consumer Protection Act, and I'll get to that in a minute, if the consumer contract that waives, limits, impairs, or disclaims a right conferred or created or a manner of enforcement established by federal or state law. Any federal law, any state law. Do you think that your businesses know, okay, this is my contract, and in 22 USC 1535, there's a provision that says that this can't be waived. So it's any state law, any law, the volumes, you got the code behind you there in the 20, 30 volumes of Maryland law, or any federal law. And in addition, unlike the bill from last year, it makes it an unfair and deceptive trade practice. Well, guess what? If you have this in your contract, whether you intended it or didn't intend it, you violated the Unfair and Deceptive Trade Practice Act, which carries a fine of $10,000 per incident, up to $25,000 if it's repeated, and carries a 1-year jail sentence. So I just think if the delegate has a specific issue like he did last year, then pinpoint it and say what it is, and we're happy to look at it. But to have it apply across the board to every single federal law and every single state law, no business is ever going to know whether they're in violation of it or not. Thank you.
Thank you. Delegate Weibel.
Thank you, Madam Chair. So the bill sponsor said he had some numerous amendments that changed this. So that's what I was going to ask. Have you seen those? So you haven't seen them. So
no. My
next question was, do you agree with the amendments or not?
I have no idea what they are or what they do.
Okay. All right. Thanks.
Vice Chair Charkoudian.
It's my understanding that part of what the amendments would do that are about to be offered are to enumerate the specific laws that it would apply to. So would that take care of your concerns?
Well, I'd have to see what laws we're talking about. I haven't seen the language. So
It sounds like your
couldn't
primary
say.
concern is the breadth of what it could apply to.
Well, I
and
think it's the breadth,
unpredictability of
and
that.
it's also the fact that unlike last year's bill, any violation is a violation of the Consumer Protection Act.
Got it. Okay, well,
That
we're looking
concerns me as
forward.
well.
Well, we're looking forward to see the amendments because I think they'll address some of what you're talking about. Thank you, and hopefully you and the sponsor can get together on that as well.
Sure.
You and your best friend can work alongside each other. Are there any further questions for Mr. Enton? Delegate Adams.
So Bob, thank you, Chair. So Bob, I think my concerns were, and I'll reiterate for your comment, is that you're taking small businesses that don't have legal teams, and I don't know how many businesses operate in the state of Maryland. Maybe I should ask the Secretary of Commerce what that number looks like. And should this bill unfortunately pass, all these companies at some certain date in the near future would have to comply with this law. And I'm just taking a brief look at this, and I'm thinking, I know at least one business person that would have to take 2 or 3 paragraphs and probably turn it into that 30 or 40 page thing that they're trying to avoid to begin with. I think that's my primary concern with this. You're not helping, you're complicating, because you're forcing businesses to assume the worst, which is at some point I'm going to violate a law, and here come the attorneys and welcome that particular fight, because aside from the cost of trying to comply with this law, which will be substantial, it would be all of a sudden you're exposing yourself to liability for which you have to defend in a court of law or arbitration or whatever. And I see it as being unworkable, would be my comment. Would you agree?
Absolutely. And let me say that, it's not just, it's for small businesses, they're never going to know about any of this. For larger businesses that have attorneys that regularly, that track what you all do down here. And, like at my law firm, we're a kind of middle-sized law firm, but we send out, bulletins to all our clients at the end of the legislative session, telling them bills that have passed that might impact them. And, but even for the larger corporations, to say that now under Maryland law, you can be fined or go to jail because you violated some provision of state law or some provision of federal law, I just think it just be a nightmare. But in particular for small businesses, because a small business isn't going to have a clue about this at all. None.
Any other questions? Seeing none, thank you very much, Mr.
Thank you,
Hinton.
Madam Chair.
That will conclude the bill hearings on House Bill 103. We will now skip over and go to House Bill 191. Delegate Wims. Is Delegate Wims here? Yes. If you have a panel, please bring them up with you.
Testing. Good afternoon, Madam Chair, Madam Vice Chair. For the record, I'm Delegate Greg Wims presenting House Bill 191, Retail Transactions, Cash Payments. This bill aims to address the increasing incidence of cash refusal at points of service in brick-and-mortar retail locations. Cash is the staple of our country. No person should be prohibited from using legal tenure when trying to buy groceries at the supermarket or clothes at a clothing store. The bill requires businesses to accept cash in a form of payment for transactions between $5 and $300 for brick-and-mortar locations. Exemptions have been in place for transactions made via telephone, mail, or internet, or a payment to park a vehicle in a metered space, parking lot, or garage. There is a sponsor amendment to change the application of the requirements in this bill transaction from $0 to $300, from $5 to $300. Including the amendment of further exemptions to the requirements outlined. I brought these forward after talking with stakeholders who will be talking after I give my speech today. The exemptions are as follows: exempting the University of Maryland system, exempting stadiums with the capacity to seat 5,000 or more patrons, exempting in-person retail transactions at vending machines or kiosks, exempting retail transactions for the rental of merchandise, heavy equipment, or lodging for which collateral is typically required. I believe these amendments build compromise with our business community while keeping the intent of the bill intact. When we first started this bill this summer, we wanted to make sure that all businesses were at the table, and you'll hear again from someone from my panel today. The bill is timely considering the privacy of cash transactions now that a lot of our credit card owners make the consumer participate in. When I say that, a lot of our constituents in the state of Maryland are what we call unbanked. In my layman's term, they don't use banks. They are hardworking people who have cash only. They don't have credit cards. The cash maximum also limits the potential to receive money laundering. This bill was presented a few years ago. That was a concern. This is why my bill goes to $300, so that would not be a concern as of today. It is well known that banking and credit card lenders' practices can be predatory and dangerous in some cases. For this very reason, many Marylanders choose to abstain entirely from the conventional banking system. This bill is needed to ensure that all Marylanders have an equal access to our economy. Those who work hard like we do should be able to buy goods by paying cash. I ask for a favorable report for HB 191. Thank you, and then we'll have our panel to go first. Did you want to start at that end? Thank you.
Sure. Good afternoon, Chair, Vice Chair, members of the committee. For the record, my name is Marceline White. I'm Executive Director of Economic Action Maryland Fund, here in strong support of House Bill 191. As many of you know, Economic Action Maryland Fund provides direct services. We serve about 2,000 to 2,500 older adults, tenants, and those who have faced fair housing discrimination each year. We serve every county in the state with particularly number of clients that we work with in Baltimore City and Baltimore County. One of the things we see with a lot of our low-income clients is the fact that they are or underbanked. And one point I want to make, as you all have been grappling with affordability this year, people are maxing out on their credit cards. A recent report found nationally 32% of people have maxed out on their credit cards, so people who might have used a credit card in the past are not able to do so anymore to pay for transactions. So we think this helps our low-income clients and also helps those working families who have maxed out because they've been struggling and are able to pay cash and manage their money through cash payments as opposed to credit cards with the interest rates right now. So for those reasons, we support HB 191 and ask for a favorable report.
Good afternoon. My name is Pablo Blanc. Thank you so much, Madam Chair and Vice Chair. I represent CASA, and we are in strong support of the House Bill 191 because an increasing number of Maryland retailers refuse cash, effectively locking unbanked and undocumented residents out of everyday necessities like food, fuel, and medicine. CASA is a national organization building power and improving the quality of life in the working class, Black, Latinos, Afro-descendants, indigenous, and immigrant communities. For many low-income families, immigrants, seniors, people living in areas with low internet connectivity, and people with limited English, cash is not only a preference, it is also a reliable way to pay. When businesses require electronic payments, they create a barrier for people who have the money in hand but are denied the ability to use it. That is exclusion, and that is wrong. Those vulnerable Marylanders should always be able to use their payment method of choice. For example, a day labor worker who has been shoveling snow around for 10 hours and collecting $200 after a very hard day of work, and they want to go home and stop by a supermarket and get food for their family, if they would not be able to use that cash, and they will have to wait until the next day to go to the bank, deposit the money, to be able to use the fruit of their work. So that is not good. That is not a good policy. Moreover, the federal administration has moved toward electronic payments. For example, the IRS is phasing out refund payments by paper checks, or USCIS is no longer accepting payments by paper checks. We have seen the stress and difficulties immigrants experience when confronted with the need of resolving these situations. Finally, sorry, if I can just 10 seconds. in a big data society, when companies are collecting all we do electronically to create profiles of us as consumers, as a personality, as our personalities, we should have the ability to buy a book, to buy food, to buy over-the-counter medicine without that purchase being linked to our persona by using credit cards so we need for privacy issues also this bill. Thank you so much.
Thank you. Very good.
Yes. Chair, Vice Chair, and members of the committee, my name is Lona Muckle, and I'm the Senior Policy Associate with the Cash Campaign of Maryland. CASH stands for Creating Assets, Savings, and Hope, and we are a nonprofit that promotes the economic advancement for low to moderate income individuals and families in Baltimore and across Maryland. Many of our clients earn less than $10,000 annually, and more than half earn less than $20,000. We support House Bill 191 because it is a simple but crucial step towards protecting unbanked and underbanked Marylanders from being excluded from everyday economic life. While cashless payments are convenient for most of us, they are not accessible to everyone. When businesses refuse to accept cash or do so with additional fees, low-income consumers have to turn to other alternate, more expensive options, and those costs add up. HB 191 simply ensures that cash remains an option so that no one is excluded because they don't have access to a bank account or they can't afford extra fees. Cashless systems should be a choice, not a barrier. This bill will ensure that Maryland's economy continues to work for everyone. For these reasons, we urge a favorable report for House Bill 191.
Good afternoon, Chair Valderrama, Vice Chair Charkoudian, and members of the committee. My name is Lynn Harris, and I am here representing Interfaith Works, a large nonprofit in Montgomery County that annually serves 35,000 plus of our residents who struggle with basic needs to remain housed and live in poverty. Among the services that we provide are emergency shelters, supportive housing, assistance with connection to health care, essential needs like food and clothes, emergency assistance when individuals who are housed get underwater on certain bills, and vocational services to help the most vulnerable upskill and job train so they can earn a living wage and stay housed. Our work is more challenging now than ever, and one of the things that we've discovered in working with our clients over the past 53 years is many of them have found as a contributor to living on the margins a lack of basic financial literacy shared by millions of Americans, and have gotten into financial difficulty because of the use of credit cards, debit cards, and similar forms of electronic payment that provide them the ability to purchase goods without showing the cash ability to actually pay for those goods. And working with our partners at the Gaithersburg Financial Empowerment Center, we know that many of our most vulnerable residents have very, very good reasons for not using any form of electronic payment. They don't have Apple Pay. They don't have Google Wallet. They don't have a credit or a debit card. They pay cash because they have to. And I so appreciate Delegate Wims bringing this bill forward, because in this time when the communities that we at Interfaith Works serve are being more marginalized than ever, and the federal government is making their lives harder every day, this bill makes their lives a little less hard by ensuring that they can pay for essential goods and services.
Thank you so much. We'll start with Delegate Pippi, then Queen, and then Rose.
Thank you. So this bill's interesting for sure, Delegate. Thanks for bringing it. Couple points. One is credit card processors usually charge a fee, right? So that's like, I feel like an argument potentially that assists the bill, right? You know, because you're not willing to take cash, you got to use a card, and then on top of it, we charge a 3%, 3.5% fee, right? The second part is, the way I read this is that if somebody walked in to an establishment with $300 in pennies, and the retailer refused to accept that, they've now committed a consumer protection violation, which is a very serious offense, jailable, $10,000 fee. So, you know, is it, if you could maybe answer those two parts, is it fair that a retailer would, and look, they don't even make the penny anymore, so, but is it fair that a retailer would have to accept $300 in pennies? Otherwise, they would be subject to some very serious violations. So maybe if you could address that.
Well, thank you for the question, Delegate. And I would say in the panel, we've been working on this issue ever since the summer. First, we don't think anyone's going to bring $300 worth of pennies in, but if they did, that sort of goes to the point why I brought the bill forward. This is probably someone who really doesn't have the cash, or they're making minimum wage, et cetera, and all they have is pennies, which again, I don't think anyone would bring that in. But the idea of the bill is that person can buy food or buy medicine. They wouldn't be penalized by not being able to buy to purchase the product, is what I'm saying. So I stand with the bill, and I think the reason we lowered the $300, because at one point I had it at $1,000, because we wanted to make sure that there wasn't that prospect of people thinking they could be money laundering. So I'll just say we think this is fair for those who.
Thank you, Madam Chair. Thank you for bringing this bill forward and this issue. I guess I have a couple questions to understand the problem we're trying to solve. So I understand when my Delegate Pippi made the comment that we wouldn't want to force people to use credit cards because most things with credit cards have some fee associated with it. But I guess I'm kind of questioning, where are we going, or where are people going where someone is telling them not to use cash? Just in my own personal experiences, I go to nail place, they're like, they rather me use cash than pay credit cards. I go to the hairdresser, they rather me use cash than credit cards. I go to the gas station, I get a cheaper cost if I use cash versus credit cards. So where are people stopping folks at supermarkets and other places and saying they have to use cash? This is happening?
It is happening. I think others can maybe add in. I live in District 40, and there are several cafes and restaurants that don't accept cash.
Okay, and so my question, I guess, is this a post-COVID thing, or our change in society where we're pretty much a paperless society? Is this what's precipitating this? Because I'm just not familiar with that. So you're telling me, and I'm wondering, is that because, post-COVID, we said we weren't going to use cash because of the concerns about health and stuff. And so because of that, a lot of people changed over their systems and things to accept more credit cards and stuff. So for instance, I went to a food truck one time and they told me they didn't take cash. Now I kind of understood that because food truck, small setting, people, you don't want people who are working on your food also doing cash, because cash is kind of dirty. So I understood that made sense. And it was a small business, so I said, well, maybe they converted over post-COVID, and so that's the best thing for them to accept that. So is this a post-COVID thing or a movement towards not using, paper as much? Because I go to the grocery store and people who use EBT cards, they're not using cash. A lot of things are on, cards in digital formats. So I'm just trying to understand the impetus of this. Is that making sense?
It doesn't. We have an answer. You want to answer that? Either one.
So I know that for cash, we began hearing about this issue near the beginning of the pandemic, so around 2020.
Right.
And I do think it is related to what you were saying. People wanted to stop using cash in order to, like, a response to the pandemic.
So it was a post-COVID time we saw more of this.
It might have been happening before, I'm not sure, but I know from our clients, we've been hearing about it since.
Yeah, that makes more sense to me than anything else. Okay, thank you.
Thank you, Madam Chair. In addition to, I guess, following up with some of the penalties, I mean, the penalties are very steep. And when you have a small private business, so let's say you are a cafe or a boutique, if you are maybe even like a woman-owned business, if you're not comfortable having cash, carrying cash around, having it in the store, that could be a real challenge. My other problem with it would be, let's say you have a brick and mortar store, but you also go to trade shows or craft fairs or festivals or things of that nature. So you're opening yourself up to the liability of, because you fall under brick and mortar, but the little squares that people carry, and they do primarily most of their business using that device. And it provides safety to both the consumer and the business owner. So I think that those are my probably biggest problems with it, combined with the penalties. So it would.
Say something.
I think that the bill, what aims is to protect the most vulnerable Marylanders, right? So the people who have cash and they are prohibited to get the goods because the person decides not to receive cash. And it's a dollar bill, right? So it's a dollar. Who can refuse to get a dollar bill? So I think that we are aiming to protect the most. So I understand your point of the small business who may also feel in a vulnerable situation from security for not receiving cash. But it's also the need of the person who needs to buy food is the only place in the neighborhood who may be open at that time and receive, no, sorry, I don't accept cash. When you have the money, you have the means in the U.S. to buy food, right? So I think that what the delegate is trying to do is protect the most vulnerable people who has the money to access the goods that they need for survival.
But would it be fair to say that there's a lot of different kind of business models, and shouldn't it be up to the business to decide what model they want to operate under without fear of penalty? I think that this is a bit overreaching, just my personal opinion, but I thank you for your answer.
Thank you, Madam Chair. My question was along the lines of delegates here. The fines seem really excessive, $5,000 for first offense and $10,000. I mean, if I'm a small business, that could put me out of business. Is that your intent?
No, it isn't. And I'm glad you asked that question. I wanted the panel to answer before I started. First, I want to say the reason why I brought this bill in the first place is that in my community that I represent in Upper Montgomery County, there are literally thousands of people, of course we have 1 million people in Montgomery County, that do not have credit cards. And they have come to me about the fact that with medicine, with food, et cetera. The second thing I wanted to say is I've worked very closely with the small business community pretty much for the last 30 years. I owned my own small business back about 15 years ago. And so when we talked and you saw the compromise we made with some of the businesses who are going to follow me, that is very important to me. So to answer your question directly, what we're trying to do is make sure that those family members who work 12, sometimes 14 hours a day, they don't have a credit card. They need to buy their medicine. One, why the first bill, the person brought the bill to me was number one. Food, et cetera, will be able to do that. When it comes to the small business, as a former small business owner, the fees are very high, and I purposely put it that way because we want to make sure that those businesses who serve the community, they're in the community that they serve, will be able to help those who need the help. And as of now, as I said, there are thousands of people, tens of thousands, according to my staff, in the state who actually don't have credit cards.
Yeah, I understand what you're trying to accomplish, but a lot of your examples, you're using examples of essentials that people need, food and medicine. So is there a way to further restrict the bill to just essentials? I mean, somebody going out and required to use cash to buy a video game, to me, is a lot different than somebody who, only has cash to buy food or medicine.
Well, I would just say with the committee here, because it's going to go to subcommittee and you work on it, I'm willing to listen and maybe we could make some compromises as we did for the University of Maryland system. But right now, I just have to talk about that. With
and then the other question, kind of along the lines of insurance, do you know what impact it would have on a small business if they, I guess a lot of employees who deal with cash and accept cash are potentially required to be bonded and insured. Do you know if this has any insurance implications on small business?
That one I would have to get back with you on, but I know from just talking with various businesses, they already have their bonding and so forth because they're in business. By the state of Maryland, you have to have it. But I can ask that question specifically because I don't know the answer.
Okay. All right. Thanks.
Thank you, Madam Chair. Delegate Weibel, you stole one of my questions there, just thinking about, I guess it'll go to subcommittee, but just want to get, I think it does make sense to think about how we can restrict this to those certain necessities, food, medicine, and, transportation, so gas or what have you. But I guess, I believe you have other what are the other exemptions that you have in the bill? Can you walk through the exemptions and how you got there?
We talked and we worked this bill. This is my first bill, by the way, that we put in it. We worked it through the summer. So we talked with not only small businesses first, medical offices, but then we went and talked with the Orioles, the Ravens, the University of Maryland, because when I first put the bill together, none of them were exempt. But when they came to me, and again, that's my thing of working with the community, small business and large business, we found out that, let's take the Ravens, for instance, because I think we have someone that's going to follow me. What they were saying is you have 60,000 people in the stadium, and they're buying hot dogs or drinks and so forth. The cash transaction would hold up the line so much that people who pay to go see the game wouldn't be able to see it. So once I heard that, and I'm a ticket, I have season tickets myself, I understood that very clearly. So that's some of the exemptions there. At the University of Maryland, I talked with the chancellor and others when they talk about going to the football games. So we looked at it that way. But when we talk to small businesses outside of this, I just heard about the bonding. I have to check on that. The issue wasn't as, they didn't like doing it because they now have credit cards, but they understood what I was saying, and the majority of small businesses in my district, is this where it started, said they could accommodate us. They understand those who are at the lower income levels who don't have credit cards, really, the only way they can survive is through cash payments.
Got it. Well, first, I have to commend you for talking to the right teams, Ravens. You started off on the right foot there. But the other thing, so in my district, I actually have the Lyric Theater, I have the BSO, I have Everyman Theater, I have the Hippodrome, all these amazing art institutions are in my district. And the reality is, I'm hoping we can talk about an exemption for them as well, because it's not as big as these other stadiums. But the reality is, when you're at a game, especially at a baseball game, you can spend all day just, you got 9 innings, you got 4 quarters. But when you have only a 10-minute, break in between a show, you need even more faster service, right? So I think an exemption for our smaller theaters would be a good way to go, because I think they actually need even quicker service at times. So I think the seat capacity part we might need to work on, but love the spirit of the bill. I think there's ways we can maybe refine it to make sure that we get to attacking the issues that you're trying to tackle. But thank you for bringing the bill forward.
And thank you for the question.
Are there any other questions? Seeing none, thank you, Delegate Wims and your panel. Before I move to the opposition, I just want to see, is Mr. Steinwedel here? Okay.
Yep. Hello.
You're in favor, correct?
Yes. Hello, my name's William Steinwedel. I'm the Deputy Advocacy Director for Homeownership Preservation at the Maryland Legal Aid Bureau. We testify in strong support of House Bill 191, and we thank Delegate Charkoudian for the invitation to testify on this very important bill. At MLA, we see that many of our clients use cash for small purchases. Just some facts, over 80% of those households making less than $75,000 a year in 2024 reported using cash to make purchases. And the average amount spent was $253, which is less than the maximum amount that was proposed in this bill. But I just wanted to talk about one brief story that I had. The client I represented about 6 or 7 years ago in a Chapter 13 bankruptcy. Her income was only about $700 to $800 a month. She fell behind on her mortgage when her son died serving this country in Iraq. So we had to file Chapter 13 to save her home. I always remember this client who, unfortunately, she has since passed away. I always remember this client because she shared the same birth date that I did, September the 22nd. She would come in every month for her trustee payment of $350 a month, and the trustee doesn't accept anything other than money orders. She would come in every month with her cash, timely, and me and her would have to go down to the 7-Eleven and get a money order every single month. And the thought that somebody similar to this wonderful client having to do that for everything in their entire lives is just not, it's not right. It's just adding another burden in an already difficult situation. So for those reasons, Maryland Legal Aid testifies in strong support of House Bill 191. Thank you.
Thank you. I don't see any questions. Thank you very much for your testimony. We'll now move on to the opposition. We have Ms. Kaylee Locklear from the Retailers Association, and we have one virtual following her.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are respectfully here in opposition to this bill. So while well-intentioned, a cash acceptance mandate is a one-size-fits-all mandate policy that fails to account for operational realities, safety concerns, and the diversity of today's retail environment. Our organization was previously open to working on this legislation in 2021, but we had to offer an extraordinary amount of amendments, that's already come up today, to work on the bill. But in that very short time, combined with rapid technological advancements, many retailers have moved toward cashless or limited cash models to protect employees, to reduce crime, and operate more efficiently, not to exclude customers. These decisions are often made by the fact that cash does cost retailers money to handle. I know that seems odd, but armored transport, security, insurance requirements, which is added costs, labor shortages, and public safety concerns. Cash mandates also reduce flexibility for small and independent businesses that may lack the resources to safely handle cash. Forcing these businesses to accept cash can put both workers and customers at risk. Importantly, access concerns can be addressed without mandates through widely available prepaid cards, digital wallets, and targeted programs to expand banking access rather than imposing these rigid rules. Retailers need the ability to choose payment methods that best fit their business model and safety needs. So for these reasons, we urge an unfavorable report, and I just want to thank the delegate's office for reaching out to us. They've shared everything with us, and we've been in constant communication. So I want to say thank you.
Thank you. Delegate Rose.
Thank you, Madam Chair. That brought to mind another question, probably similar to my first one. So, you know, in the example given of the small cafes or small boutiques, you know, the places like on Main Street, that type of place. So a lot of times they hire teenagers, you know, young people. And so I would think that it would be a lot safer for a young person. Do you think this would stifle hiring? Because you also would then need to, you know, be sure that you have someone there, you know, if a teenager's running the store, taking the payments, if they don't know how to look for counterfeit, for anything that could be, you know, not correct money to use, that puts the business at risk and then can trickle down. Can you just speak to that?
Absolutely. So just in general, cash does increase the risk of robbery. It increases employee safety concerns. And cash attracts a whole bunch of different issues, as well as internal theft. But some insurance mandates, and I hope I have an opportunity to get into that a little bit, have caps on the amount of cash that you can even have on hand, which means that individuals have to make bank runs consistently to abide by their insurance requirements. So I just wanted to throw that out there as well.
Thank you.
Hi, I have just a quick question. So if a place doesn't take cash, how would a consumer buy a prepaid card?
So there are prepaid cards that are available via banks. There are kiosks that offer them. And beyond that, because so many individuals carry phones on them now, this is why I referenced the digital wallet, which honestly is probably the easiest way to deal with a variety of retailers at this point in time.
I don't see any other questions. Thank you very much. Thank you. We do have another unfavorable virtual, which threw me off. I thought it was Senator Karen Lewis Young, but it's another Karen Lewis Young.
No, it's me, but I used to work for Karen Lewis Young, but I changed my name in there, so it should be my name, but they didn't catch it in time.
Okay, so clearly you're not virtual, so.
Yeah.
And are you testifying unfavorably?
Yeah, I'm
Okay,
testifying.
I will allow it.
Okay, thank you. Hello. Okay, this works. Chair and members of the committee, my name is Charles Rignanti, and I represent the Health and Fitness Association, which represents more than 800 fitness facilities and 8,000 employees across Maryland. I did speak to the delegates' staff today, and after speaking with the staff, we are now favorable with amendments and not unfavorable. We understand and appreciate the purpose of HB 191 to ensure unbanked Marylanders can access groceries and basic household goods. That is an important consumer protection goal. However, as written, this bill extends beyond that intent and would unintentionally sweep in fitness facilities where most of those concerns do not apply. Fitness facilities are not retail stores selling groceries or household necessities. Most people who enter a fitness facility are already members, paying through a reoccurring monthly or annual agreement. Unbanked consumers are not relying on fitness facilities to obtain essential goods. Fitness facilities also operate on thin margins. Requiring cash acceptance would force facilities to install safes, increase insurance, manage reconciliation, and absorb loss prevention costs that many simply cannot afford. Mandating cash on site also increases safety risks, particularly during early morning and late night hours when staffing is minimal, putting employers and members at risk. For these reasons, we respectfully request a target amendment under line 17 to exclude fitness facilities providing services for the preservation, maintenance, encouragement, or development of physical fitness or physical well-being. I've already spoken with Delegate Wilms and about this amendment, and we appreciate their willingness to engage. We look forward to continuing working with his office to ensure HB 191 achieves its goal without creating unnecessary safety and cost burdens for fitness facilities and consumers. Thank you.
Thank you, Mr. Regan. I will acknowledge that your email was here, but your name change wasn't there.
Yes.
So
Yeah.
I allowed it, but I will let those who are here know we'll not make that a habit in here.
Sorry.
So, no, it's fine. It's at my leisure, but I just want to remind everyone, I'm following the new speaker's mantra that people come a long way to testify, so we will allow it, but we do respectfully request you follow the policy of the committee. With that said, are there any questions for him? I see none. Thank you very much. That concludes the bill hearing on House Bill 191. Members will now go back to House Bill 85, Vice Chair Charkoudian's bill, Cooperative Limited Equity Housing Corporations. Yes, please.
All right. Madam Chair, colleagues, for the record, Delegate Lori Charkoudian asking for a favorable report on House Bill 85. It's exciting to have housing here, isn't it? So part of what we're learning about is that there are a lot of problems with affordable housing and the lack of access to it. And there's a lot of different solutions, and we really need to look at a bunch of different solutions. And so today I have a bill that's about limited equity housing co-ops. And I think of it as one tool in the toolbox. So by itself, it's not going to solve our affordable housing problems, but along with many of the other things that we're considering this year and will consider over the next several years, it's an important tool. And so I just want to talk a little bit about how it works, and then I have experts on the panel who will also talk about that. The basic idea behind a limited equity housing co-op is that if you have a bunch of people who come together and want to create a housing co-op, but want to do it in a way that doesn't lead to massive increases in the costs of the units in that co-op and lead to gentrification. Right now, there's not a tool in the state to do that. And we know that because, and we'll hear from Sasha in just a moment, in my community, a bunch of tenants took advantage of the Tacoma Park right of first refusal, purchased their building from the landlord, and wanted to create a limited equity co-op to make sure that that building stayed affordable home ownership in the long term. And after trying 10 ways to Sunday, working with all kinds of attorneys and multiple calls from me to the Department of Housing Community Development to see if we could solve the problem, calls to the Attorney General's office to see if we could solve the problem, it became clear that we really needed to change state law so that there was a structure that would allow for a limited equity housing co-op. I think it's worth thinking about limited equity housing co-ops as a tool to certainly keep a particular building affordable in the long term, affordable home ownership in the long term, Also to think about them as a way to keep affordable housing in a community that might otherwise be gentrifying. And so with that, I'm going to request a favorable report, let my panel talk more about the specifics of how it works. And I'm going to have you go first.
Chair Valderrama and members of the Economic Matters Committee, good afternoon. My name is Sasha Olenek, and I am the president of the Leland Tenant Association, or the LTA. The LTA is a group of neighbors committed to nurturing the sustainability of our larger community, keeping our homes safe and affordable, and supporting each other's well-being. If you're interested in more details of the membership of our committee, I refer you to my written testimony. In 2021, our landlord put our building at 112 Lee Avenue in Tacoma Park up for sale, which threatened to displace the 15 low-income households living there. In October of 2022, the Leland Tenant Association utilized Tacoma Park's Tenant Opportunity to Purchase law to successfully acquire the property. The LTA's intention has always been to convert the building to a limited equity co-op, ensuring that it would remain affordable and owned by the residents in perpetuity. Although more than 90 limited equity co-ops thrive in the District of Columbia, there are none in the state of Maryland. We soon learned the reason why. The existing state laws make the creation of a limited equity co-op confusing, expensive, and time-consuming. HB 0085 would simplify and streamline the process and allow more. Our example. The bill, were it to become a law, would create another tool to stem the growing affordable housing crisis within the state of Maryland. I urge a favorable report on HB 0085.
Go ahead, Scott, whoever.
Madam Chair and members of the committee, my name is Scott Bruton. I am the Director of the Department of Housing and Community Affairs of Montgomery County, Maryland. The Department of Housing and Community Affairs worked intimately with the tenants of the Leland in helping them to try to create their limited equity co-op. We experienced the frustration with them in trying to get over the legal hurdles, but we did fund the creation of this. Currently, they have a corporate entity that acts like a limited equity co-op, but they hope to become a full co-op. I am here to testify strongly in favor of the passage of this bill, and I want to let you know that I speak from experience about the value of limited equity cooperatives. Before joining DHCA in Montgomery County, I worked for over 12 years for nonprofits in the District of Columbia. While there, I helped tenants form several limited equity cooperatives, and I also helped with those that had been in existence for several decades. I am also the co-author of a study that looked into the history, the more than 50-year history of limited equity housing cooperatives in the District of Columbia, how they have fared over time, how they have, as the delegate said, very effective in preserving affordability as an interesting homeownership model over time. And I encourage you to vote in favor of this bill to allow more residents of the state of Maryland to take advantage of this exceptional way to preserve affordable home ownership in Maryland. Thank you.
Good afternoon, Chair Valderrama and members of the Economic Matters Committee. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network of Maryland. You have my written testimony strongly in favor of House Bill 85, but I just want to make a couple of points amplifying what has just been said. This is a really important model for us to grow in the state of Maryland, this cooperative model. It's an opportunity to also provide ownership for community members and for folks to collaborate and move collective ownership forward. This is not something that has been, Maryland has not had the ability to do this. So it's just very clear to me that we need more options for ownership for people throughout the state. And this is one limited equity co-ops is one strategy towards that, and an important strategy towards that. And it's not just an interesting model, it's a valuable model because you have collective groups of people working together and establishing a model, and also establishing affordability going forward. So when a tenant moves out, then it would make space for another tenant to have an opportunity to own as part of that cooperative. So I would just urge you to vote in favor of House Bill 85. And I think that we need a number of different strategies towards housing production in the state of Maryland, and limited equity co-ops is one clear path forward. Thank you very much.
Thank you. We'll start with Delegate Queen and then Adams.
Taking notes. Thank you, Madam Chair. Quick question about the model. What other states use this model?
Do you know? DC is the one I know. What other states have it?
Multiple other states. You'll find the most concentrated in California, in New York, especially in larger cities, and in the District of Columbia. They also exist in smaller concentrations in a variety of cities around the country. So it is a national model. Housing cooperatives themselves have actually been around since the early part of the 20th century. Condominiums are a relatively
Not the specific model. I don't need a history on condominiums. Thank you, though. Okay. Other question, Mako, for the sponsor. Mako had an amendment. Did you see that, or are you amenable to that amendment?
Yeah, I'm fairly certain. The amendment, basically, the intention, essentially, yes. I think they want to make sure that our intention is that the local government can't add additional requirements to limited equity housing co-ops. And I think they would just want to make sure that doesn't override, for example, their zoning authority, that kind of thing. So yes, I think we're going to accept that amendment.
So I'm very familiar with the cooperative business model, and I just want to make sure my understanding applies to what you're trying to do. So a cooperative has members, and in this example that you're bringing today, you have 12 units in this building?
15.
So are there 15 membership interests that are part of this? In other words, are the individual people living here, are they acquiring, or is this cooperative creating a interest, as I understand it, through a cooperative business model?
Yes, it's the same model. Yes.
And the reason for the phraseology in the bill of a limited equity, is that because you have to borrow a lot of money? In other words, because of the nature of this, you don't have a lot of equity you can put in the project? Or then explain for me, if the answer is no, what is the reason for the phraseology of limited equity? Because I'm thinking of it as a business thing. You might be able to...
Sure. So a limited equity housing cooperative, as you indicated before, members have shares in the property, and the buy-in cost, the buy for the share in a limited equity housing cooperative is usually quite low.
You can stop right there. That answers the question. So in other words, the limited equity part is easy to buy in. So how does the business, how does this cooperative acquire the property? Okay, so if you've got a property owner that's selling the 15-unit building and it's worth, I mean, I'm not, $10 million, let's say, maybe $5, whatever that number is. Obviously, you have to either have the cash or find money through private equity or through banks. So I'm worried and or concerned about the business model that relates to how much is this being leveraged, and are you worried about the risk of something like this falling to failure because of the limited amount of equity that goes into the purchase, is where I'm headed with this.
Can I try to answer that question?
Absolutely.
So I think the thing that limits the equity is really more important than when you first purchase it. It's going forward, right? So if you think about Tacoma Park, for example, where property values are increasing significantly year after year. And so if you have 15 people who buy into that, and we'll get back to how they buy it, but the 15 people buy it. Sure. Now 10 years from now, the property value of a particular unit has increased significantly and is potentially no longer affordable to the next person who's going to move in there. And that's the gentrification part of it.
Yes, okay.
And so the commitment that people are making when they enter into a limited equity co-op, this is limited equity, is that their property, their unit, is only going to increase in value according to essentially inflation. So it's not going to increase in value along with the rest of the properties around it. So that's where if you have gentrification happening generally, these units stay affordable in the long term. And that sort of is the commitment that people who start that and anyone who buys into it understands when they're making that purchase. That's the limitation on the equity that would otherwise grow based on property value. So that is the thing that is different about a co-op that, you know, you could have 15 people buy and create a co-op now. You don't need to change the law. So that's what the limited equity on this system is. To the question about how do they buy it, I believe it was a combination. They could tell you there were grants that we actually got a bond bill for them. There were grants from the city, and then individuals who were tenants also put up their own money as well. And so in terms of thinking about it as a tool, the reason the city of Tacoma Park, for example, was willing to put in some money towards that is this idea that not only were they going to help keep these 15 tenants in place who are now going to become homeowners in this unit, but also that in supporting these tenants to stay there when any one of those tenants, homeowners, co-op members, leaves, they knew that the next person who would come in would have an affordable purchase. It wouldn't be they were coming in and buying now an inflated unit compared to like the rest of the city.
All right, I'm only going to ask one or two more questions. I find the bill interesting just because I understand cooperatives. So your idea here is that you're saying in 2026 you acquire something, you create the cooperative. There has to be a value to the membership interest. And so the trade-off is that stays static. That stays the same. If the building increases over 20 years and doubles in value, maybe the average investor sells the property. The cooperative probably has in its bylaws the fact that you can't in fact sell this. That you are agreeing in 2026 to forever hold this in some degree of partnership amongst your other cooperative members to do a certain thing. And so when the member leaves, are they selling?
Yeah.
Okay, so you understand where I'm headed with this. So they're selling, but they're selling at an agreed upon limited price that you agree to in 2026.
Yeah.
Okay.
So
I'll have a series of other questions, but every one of those can be handled offline.
Happy to talk about it.
I find it interesting.
It is.
I hadn't heard the business model before.
Yeah, it's cool. Thank you.
Along that line, so I'm buying something at a discounted amount and I sell it later, there's no real equity here, is there?
It's limited, hence the name, yes.
I get that. I guess, what market are you trying to capture? Is the intent to give people a place to live? Because it's not building the wealth for me to go to the next place, if you know what I'm saying. Is it?
Yeah, the intention is to keep affordable housing affordable. And so I think you want to think about it as there may be some people who are able to pull their income together to make a purchase that they want to be an investment that grows over time, and other people who want to be part of a community where they're sure that they have a roof over their head and they're sure that when they finish with the roof over their head and go on to whatever else they go on to, the next person can afford to have the roof over their head. And so it's not a wealth building in the same way as you might think about it. It's a guaranteeing affordability in sort of perpetuity way of thinking about it.
I guess it kind of confuses me because I'm not sure what we're doing here other than giving somebody a house for a little bit of time. And the next step is not really, there's no real opportunity to go to the next step.
Well, we're not giving anyone a house. I mean,
You're not giving, but
we're authorizing a structure where people who choose to come together and create this kind of a co-op, as the tenants at Leland did, and as 80 different people, sets of people, 80 different buildings in DC and hundreds of buildings in New York have chosen to do, that their interest is in owning their own home as part of a co-op and they're going to come in with a more affordable price because they're coming into a home that they understand is going to grow and, according to like inflation, but is not going to rapidly increase in its value. And so when they sell it, it will still be affordable to the next person.
Okay. It's confusing, maybe, it's confusing to me, but I understand where you're trying to go with it. I don't know what the gain is here, and I don't know how you get out of it in the end.
The gain is affordable housing, permanently affordable housing, and
But how long can you keep it affordable based on the current environment? I mean, things are growing exponentially. That's one of the problems we have. Every house is now appreciating, which means your taxes are going up and up and up. At what point does it stay affordable to where even a modest income can't get it?
I think that's the point. So keep in mind, this is an option. We're not we're not forcing anyone to enter into a limited equity co-op. But the people who choose to do it are saying, instead of my property doubling, tripling in value in the next 10 years, my property is going to increase, my equity in this property is going to increase based on inflation over the next 10 years. So it is going to stay as affordable as the day that I moved in there, so that when I choose to move out, and you do tend to have long-term residents in these communities, which has another value, right? Like permanent, long-term cooperatives, community, people supporting each other. When I choose to move out, it's not going to have double and tripled. So the next person who's coming along is going to be able to afford to get in there in the same way that I was able to afford to get in there, because it's increased by inflation, not by property value increases.
Is this being done anywhere else that I could look at?
We just talked about multiple other places.
Okay.
Yeah, multiple other states. We'll get you the full list.
I think I get where you're going. It's hard to grab it and say that it won't increase and how that's going to hold true.
Well,
Because things will go up. I understand what you're saying. Thank you.
And she usually wants just one person.
So the scenario where in 20 years from now, you've got these 15 members of the cooperative and the value of the asset has gone from the $5 million example I had to, say, $30 million example. What happens when a majority of the members of the cooperative, or maybe unanimously all the members of the cooperative, say, hey, man, I'm out, let's cash it out, let's sell it? Can in fact, the cooperative dissolve? Is it allowed to dissolve?
So to kind of add some texture to some of the answers to both of your questions, the Department of Housing and Community Affairs in Montgomery County lent the money to provide over 90-some% of the acquisition and rehabilitation costs of this property. Along with this money comes a regulatory agreement, and those regulatory agreements are for at least 40 years. Some are longer.
So let me just say, so I'm familiar with that. So you've taken grant money, you've created a project in this format.
Loan money.
At the end of the 40 years, in theory, you can't prepay this or you can't get out. Okay, so the question remains, there are plenty of examples why a organization dissolves. Some of it can just be 40 years came up and, okay, so it sounds like to me in 40 years in this scenario, there could be this exit strategy, but there could also be something terribly wrong happens with the building, or maybe you have a revolt amongst the members and things aren't happy or safe or whatever it is, and do the members have the ability to control outcomes for which you and I may not sit here today and imagine it, or would want to imagine it, but it's quite possible that there would be a future group of cooperative members that under normal circumstances could vote to change things dramatically. And I'm assuming your answer is going to be no, because these are not deed restricted, but they're restricted in the sense that they're taking almost all the money from some grant and paying for this exercise, and in exchange for that, they're entering into this cooperative and benefiting from this locked-in membership interest that will survive multiple changes over time.
I think you want to distinguish, though. In this particular case, Scott's talking about a grant that they received, a loan that they received, but I just want to be clear, what the bill does is it's authorizing enabling legislation. So it doesn't necessarily come with a loan or a grant or anything else. Like, they often could start that way, but that's not what the bill does. So the regulatory requirements associated with this particular loan are not part of the bill. So the bill is creating a different type of a corporation, and a corporation can cease to exist, and the bill has references to that as well.
That answers my question.
Yeah.
Thank you.
Thank you, Madam Chair. I guess along those lines, I'm just trying to understand in practical terms how this would work. So if we take the Leland Tenant Association, just say there's 15 members, you said there's 15 low-income households living there, but say there's 15 members total. So I just take this building and I'm a current occupant, I have a basis. Say it's $100,000 per tenant, whatever. 20 years down the road, how do the members get in, buy in, and how do they get out? How do they leave?
How do they leave?
And at what basis do they buy in? So say 10 years down the road, you said you have elderly there, a lady dies, so her interest would cease. So what basis does someone use then to buy into that property? It was, when it was originally established, it was $100,000, right, per person. So what is that basis now if someone wants to buy that unit or buy into it?
Well, I think as the Delegate Charkoudian was saying, it would only raise according to inflation.
So it's in the law that it only can increase by the rate of inflation?
Right.
So if we have an inflationary period of 11 to 15%, as we did a couple years ago, that value would go up by that?
Yeah.
Okay. And then if someone wants to dissolve this, you have majority.
The corporation would have to dissolve as a corporation, not an individual, right? I mean, individual can leave.
But you have a methodology in here by which the majority is needed to do that, right?
Yes.
Okay. Okay. And the inflation factor is in the bill?
I'm pretty sure it is. If it's
Okay.
not, I'll get it in there. I mean, it's supposed to be in there.
Okay. All right. Thank you.
Thank you, Madam Chair. Super quick question. If I can get like the 90-second version.
Unlikely.
I know that we are dealing with a housing shortage. I just want to better understand, how does this bill work towards, you mentioned it earlier, Delegate, that it would create more opportunities for housing stock. So I'm trying to understand, how does this bill create more housing stock in 90 seconds? 'Cause I know you could probably give me a whole
Well,
thesis.
I didn't say it creates more housing stock, but I do have an answer to that.
Okay, yeah.
I didn't say it creates more housing
I thought I
stock.
heard
What I
that.
said is it creates more affordable housing.
Got it, okay, I misunderstood.
But I will say that this particular building that these tenants have managed to secure, based on everything else happening in Tacoma Park, would have been knocked down, and instead of 15 homes, you would have had one.
Got it, okay, no, that's great, no, thank you. Shorter than 90 seconds.
Thank you, Madam Chair. So the question I have is once again, I just like to get to, the brass tacks of things. What's the difference between this versus a condo? And how does this make it more affordable when resale versus a condo? Like how does the condo, no, let me start over. How does this LEC versus a condo, what's the difference between that? Let me just get to that. What's the difference between this and a condo?
The main difference is you buy a condo, property values rise around you, the condo value rises with that. So if you have significant increase in property values, your condo is going to be way more expensive when you're ready to sell it. In this case, you're limiting the ability of the value of the unit to increase with the property values around it, and so you keep that unit affordable in a context where you otherwise have rapidly increasing property values.
And for resale of this particular, of your unit, does that have to go through a board or something like that for you to sell your unit or your property?
I don't think so, do you know?
Or can you just sell it, period?
you can sell your share. Another distinction between a condo and a co-op is the condo, you own your unit.
Yeah.
With a co-op, whether limited equity or market rate, you own the right to live in your unit. And so it's that right to live in the property that you would be selling. And people can pay direct cash, or you can actually, depending on how much the share costs, you could get a loan to buy that as well. And so people do sell shares in market rate and limited equity cooperatives independently of the board.
Well, I just want to thank Vice Chair for bringing this. This is very, very interesting. I really think that we should definitely take a good look at this because I really like this. So thank you very much.
Thank you.
Chair, just to confirm, I know this is a lot to digest. Just to confirm, this bill does not force any property owner or tenant to convert, right? It only applies when a nonprofit voluntarily chooses this cooperative model, correct?
When a group of tenants or a group of owners choose it, yes.
Yes, another question, and under this bill, existing tenants are required to receive advance notice, an opportunity to purchase, and protections, like relocation assistance if they choose not to participate. Is that right?
That's right.
And the last one, finally, is it correct that the purpose of limiting resale and appreciation is to keep these homes affordable for future low and moderate income families over the long term?
That's correct.
Thank you.
Thank you.
Rachel Gatson and Dominic Wojciko.
Madam Chair, members of the committee, Don Butchko with Mako here. I'm here in support with amendments on House Bill 85. Our amendments were already discussed. I just want to thank the Vice Chair for working with us. Housing is a priority for Mako this year. And so background, our amendments are just clarifying. There's similar language right now existing in state statute regarding condos. We're just asking that this bill conforms to that, so it still preserves our local land use authority, et cetera. Thank you again, Madam Vice Chair, and we urge a favorable report with amendments.
Hi, my name is Rachel Gadsden, and I have been a Baltimore resident for a little over 5 years. And for the first 3.5 years in the city, I was a renter. And in that time, I rented 6 different places. The first one was pretty nice, but I couldn't control the temperature. But at least it was decent. It was a good apartment, right? Until they raised the rent. But my income didn't go up, so I couldn't stay. The second place had mice, and I tried to wait it out until the homeowners could find a cheaper exterminator. But the smell of rotting mice in the walls and finding mouse poop in my toaster kind of sealed the deal, and I left. So I found another apartment, and I signed a lease. I packed up all my stuff. And the day that I went to move in, I found mouse poop and poison in the kitchen that they had hidden and cleaned up before I had toured the property. So luckily, I have some experience with tenant organizing, and I did a little research, realized I could get my deposit back since I hadn't moved in, and I ended up living with roommates after that and saving up, and I was able to buy a house 2 years ago. But I'm here because I don't think you should have to be able to buy a single-family home to live with dignity. This bill doesn't hold slumlords accountable or protect renters from the horrible conditions that many, many face, but it makes it easier to create one of the many alternatives that we need to support housing justice. I've also spent the last 3 years working with community land trusts in Baltimore and creating permanently affordable housing. This is just one of the options, and it's an easy win. It's an easy yes.
Thank you so much. Any questions? Yes, Delia Howard.
Thank you, Madam Vice Chair. You've looked at the bill, Mako. What parameters are on the bill as far as population density or need in a certain district. I mean, we tie housing and development to school density and school population and those type of things. So is there anything in the legislation that talks about enabling this at the local jurisdiction where the need might be greater?
So I want to make sure I understand the question in the context of like what this bill does versus what this bill doesn't do. This is not a land use bill that would impact density, and it's not creating a new public facility or something like not putting in a school where you're going to see more traffic. This is just kind of changing the ownership model of a potentially existing structure.
Right.
And so the way it was drafted, we interpreted that it said that you couldn't, local jurisdictions couldn't enact any law, or it was something similar to that. And so we were concerned that code enforcement example, that would be preempted, and that wasn't the intent of the bill sponsor. And so our amendment just clarifies that. But this isn't the type of thing where it would impact zoning. I don't think that's how it was drafted either.
Well, we have other bills that would impact zoning, and I'm wondering how they would work in conjunction with this. Maybe, we've got bills, I think it's HB 238 that's coming before this committee that would completely remove local controls, those type of things. So I was just wondering, and a lot of times these bills come in phases, and this is not mandated and people can do it now if they want to and those type of things. And I've seen that, maybe not with this particular subject matter, but I've seen that before, and that's phase one. Phase two is that it is mandated. So I was just wanted to get your feedback on that. How would it work with some of these other bills? I mean, is that something that MACO is looking at and exploring, or?
Yeah, so great question. I can classify this bill as a big old bear hug. This is a good bill that will help affordable housing. With the amendment,
I agree.
there's no reason that the General Assembly shouldn't pass it. The other bills, we have thoughts, and you'll be hearing from us.
Thank you.
I don't know if Dominic's ever said that about any of my other bills, but thank you. I'll take bear hugs. Any other questions for this panel? All right, that concludes the bill hearing on House Bill 85. Next, we'll go to House Bill 144, Delegate Vogel. And do you have a panel? You don't have a panel. 144?
No, just me.
Just you, okay.
Yep.
Go ahead.
Thank you, Madam Chair, committee members. Here with House Bill 144, the Maryland Fair Pricing and Competition Enforcement Act. So across the state of Maryland, and really across the country, we are seeing independent grocery stores, small independent grocery stores, and small independent pharmacies closing down. They just can't afford to stay open. It is an issue of bipartisan concern that impacts both urban and rural communities across the state. One of the reasons for this is the lack of enforcement of the Robinson-Patman Act. The Robinson-Patman Act was passed in 1936 and prohibited price discrimination by suppliers where large buyers receive discounts compared to smaller buyers, and you can imagine what this does to small independent grocery stores that are having to compete with giants like Walmart. Walmart is getting $1 out of every $4 being spent in this country on groceries is going to Walmart. So small independent grocery stores, there was actually just a report that was done where some small independent grocery stores are actually having to pay more to buy a product from a supplier than stores like Walmart are actually charging on the shelf. And that is because of special arrangements they have with large suppliers. Pepsi and Walmart are really the perfect example of this. They were under investigation by the Federal Trade Commission for violating the Robinson-Patman Act. It's important to note that starting in about the 1980s, the Robinson-Patman Act stopped being enforced at the federal level due to a change in the presidential administration at the time, and it really never started getting enforced again until the FTC under President Biden. The investigation then led into a lawsuit against Pepsi for providing special discounts to Walmart that then allowed Walmart to charge lower prices, which was just devastating to small and independent grocery stores across the country. This eventually leads to prices being higher for consumers. If a local community is left with just a Walmart, then Walmart can charge whatever they want for the consumers. What this bill does is provide the necessary resources for the Attorney General to begin enforcing protections against price discrimination here in the state of Maryland. We already have these protections written into law in the state. We just haven't been enforcing them. And not only is that a problem for our small and independent grocery stores, which then leads to higher costs for consumers, I see the testimony here from DBM that argues that this could reduce general fund revenue if we pass this bill, because we're dedicating more resources to the antitrust division under the Attorney General's office, when in reality, if we were doing more investigations and actually enforcing these laws that we have in the books, then we would actually be seeing more penalties, and that would actually be generating the revenue that DBM is arguing that we would be losing here. So this is essential given that the federal government is abdicating its responsibility now to enforce the Robinson-Patman Act. And I should just add one more thing about this that makes it really interesting, which is that the federal government dropped the lawsuit against Pepsi just days after President Trump was inaugurated. Pepsi gave $500,000 to the Trump Inaugural Fund, which was significantly more than they had ever given in previous inaugurations. And then just days later, the lawsuit against them was dropped for violating the Robinson-Patman Act. So for all these reasons, I urge the I urge the Attorney General to start enforcing the RPA protections that we have in place in Maryland law, and I urge this committee to give a favorable report to House Bill 144 so they have the resources to be able to do that.
Thank you. Are there questions for none? Seeing none, that concludes the hearing on House Bill 144. We'll move on to House Bill 148, which is also Delegate Vogel. And do you have a panel?
I do, and folks, want to just come up if you're testifying in favor?
We have
please.
Marceline White, Jane St. Louis, Kayla Mock. No, it's favorable amendments. Do you have others?
Nope.
You good? Okay,
Yep.
Whenever you're ready.
Thank you, Madam Chair. Here with House Bill 148, which seeks to address AI price gouging and wage fixing. With the rise in artificial intelligence and the collection of data on consumers and workers, we are now seeing companies, businesses start to use artificial intelligence and personal data to set custom prices for consumers and custom wages for workers using surveillance data and personal data on those workers and on those consumers. What this means is for consumers, higher prices at the grocery store, higher prices when booking rides on a rideshare app, higher prices when buying a flight, really higher prices across the board. And what it means for workers is A, lower wages, and B, this regime of surveillance where workers are being really tracked for every move. There's now companies that are looking into having their workers wear cameras to track if they drop a box and then deduct or dock their pay as a result of that, right? We're seeing delivery drivers, there being cameras where if you look at the mirror too many times or, they can dock your pay from that as well. Really just this regime of surveillance where workers are under that surveillance 24/7 when they're at their job and really looking at their personal data as well, even when they're not at the job site, to determine what wages they might be able to get. On the surveillance pricing front, on the consumer front, Instacart, there was an investigation into Instacart recently that found that they were actually grouping consumers into different buckets depending on different characteristics of personal data and then charging them different prices depending on their personal characteristics. After that investigation, Instacart actually said, okay, we hear you, we're not going to do that anymore, but there is discussion of a number of additional businesses that are looking to engage in AI price gouging and wage fixing. I will note there are some amendments here. Kayla Mott can speak to one of the amendments regarding electronic shelving labels and an amendment that seeks to address that. And I just want to quickly, to close out here, point out that we do have a letter of support from the Attorney General's office, specifically the Consumer Protection Division, and they had 2 amendments that we've already gone ahead and drafted, and both those are friendly amendments. And I think it's important to note, given the opposition testimony, that there is very specific language in this bill around discounts. So if you look at page 3 of the bill, this bill does not prohibit customized prices to a consumer or group of consumers when the different prices are based on differences in cost provided good or service, or the terms of a discount or reward are available and accessible to each consumer, and if the discount or reward is offered uniformly to each consumer who meets the disclosed eligibility criteria, such as senior, student, teacher, veteran, member of the military. So the testimony that says that this would somehow end senior discounts or student discounts or teacher discounts is not true. So with that, I urge a favorable report on House Bill 148, and I'm happy to take any questions.
Panel speaking? I'll go. Madam Chair, members of the committee, thank you for the opportunity to testify in support of HB 148 with amendments. For the record, my name is Elizabeth Bobo, and I'm the Legislative Director at the Maryland State and DC AFL-CIO. Surveillance-based pricing breaks the principle of a fixed price system, which was introduced in the 19th century. Today, companies can analyze everything from your location and demographics to your browsing patterns and shopping history. With that data, they estimate what you might be willing to pay. 2 people looking at the same exact product at the same moment can be steered towards different prices, not because of discounts or cost differences, but because an algorithm has determined them to be different. Let's be clear. That is discrimination by algorithm. It erodes trust, exploits personal information, and perpetuates predatory practices by companies to the point where consumers become vulnerable. HB 148 takes an important step toward restoring fairness in pricing by prohibiting this type of price manipulation. This concept is not unfamiliar. States including California, Minnesota, Georgia, Colorado, and Pennsylvania have been considering similar measures to tamp down on this practice. While we strongly support the substance of the bill, we respectfully request an amendment to strengthen its protections. HB 148 should include a ban on electronic shelf labels, or ESLs. ESLs enable real-time individualized pricing. Instead of a paper tag that shows one price for everyone, ESLs allow a company to change prices instantly several times a day for different customers. Without this prohibition, companies will continue to implement surveillance-based pricing at scale. If HB 148 is going to meaningfully prohibit surveillance-based pricing, it must also prohibit the tools that make it possible. To truly protect both workers and consumers from the dangerous overreach of surveillance pricing, this loophole must be closed. For these reasons, we urge a favorable report on HB 148 with amendments. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Kayla Mock. I'm here on behalf of over 10,000 members at the United Food and Commercial Workers Union, Local 400, many of them working in grocery retail, helping keep us fed. The goal of surveillance pricing is really nefarious. It's to infer the maximum amount of consumer will pay based on needs, wants, demographic, or circumstances. And so we appreciate the sponsor bringing this bill forward and being open to our amendment with the ban of electronic shelf labels. And so I want to talk to that really quickly. So surveillance pricing already exists. It exists online. There's very little transparency around what one consumer is paying versus another. However, electronic shelf labels are really what is going to bring this practice into brick and mortar stores. And so, you go into a store now and there's paper tags. Paper tags really create an equitable system where pricing is clear and concise for every consumer in the store. ESLs, or electronic shelf labels, create customer confusion and anger in which employees are often left dealing with. They also lead to job loss. Employees spend hours changing paper tags right now, and replacing these jobs are harmful to workers. ESLs have trackers in them to track consumers' movements throughout the store and often are manufactured by Chinese companies. And lastly, banning ESLs will truly stop the practice of surveillance pricing in brick and mortar stores and protect customers from this really nefarious practice. And again, I want to be clear, this bill does not harm discount programs or apps. And again, we appreciate the sponsor bringing this forward and working with us, and so we urge a favorable report.
Good afternoon. My name is Jane St. Louis. I am a scan coordinator and have worked for a retail store for 33 years. I am also a proud member of the UFCW Local 400. And today I'm speaking on behalf of grocery workers across Maryland and across this country. I want to share what pricing looks like from a worker's side, because it is very different from how it is often described. Customers assume prices are the same for everyone, but with retail apps, that are no longer true. Two customers can be standing side by side, buying the same item, but paying a different price. When customers realize this, they are confused, frustrated, and turn to workers for answers. But that puts us in an impossible position. We are expected to explain technology, data collection, and pricing systems we do not control. These systems collect personal data, what people buy and how they shop, to decide what or who gets better deals. Retailers call it personalized savings. From the worker's point of view, it creates unequal pricing, confusion, and stress on the front line. Electronic shelf labeling will make this worse. Customers will have no way of knowing if they got a fair price or being quietly charged more. This bill does not stop discounts. It protects customers from having personal information like race, gender, family status, or pregnancy as a method to charge higher prices. And this is not just about pricing. As pricing becomes automated, jobs are disappearing. Across retail stores nationwide, scan coordinators who work 48 hours per week full-time are now being cut to 8 to 10 hours a week, losing healthcare and stability, decades of service. Thank you.
Delegate Weibel.
Thank you, Madam Chair. Just trying to understand how this would work in practicality. So as far as the wage component of it, I had family members who used to work for a furniture manufacturer, and they would do time studies and see how long it would take to make a certain component of a chair or whatever, and then they would get piece rates based on whether that employee did better or worse than that. Does this bill forbid that type of activity?
No, Delegate, this is specifically focused on surveillance of personal data in particular, right? So it would be if, and I can give you a number of different examples, both on the wage fixing side and the price fixing side. On the price fixing side, for example, let's say a company knows that you have asthma and therefore charges you more for an inhaler than someone that might not have asthma. They know I love Nutella, right? They might know that you don't like Nutella as much as I do, so they charge you more.
You're getting to the retail side of it. I have a question on that too, but as far as the wage side, how it seems to forbid setting of wages based on surveillance. And does surveillance include like time studies and stuff like that?
Define time studies.
Well, as I just explained, someone would watch an employee work and they would develop an average rate of time that it would take for them to produce a component, manufacture a component, and then they would base their wages based on that. It would be a piece rate. So you got, $20 an hour if you produced 15 widgets instead of 10, you got a bonus based on, producing 5 above the average. It seems to prohibit setting wages based on surveillance-based initiatives. Am I reading that wrong?
I think that's a fair question. The real concern here on the wage side, and I'm happy to work with you on how we actually draft that language ultimately, and maybe there needs to be a carve out for that specifically. But it's, if someone has personal information on how close you are to retirement or on your health condition or any other personal data on you that they've been able to collect, and then they set your wage or your salary accordingly, right?
So this is only looking at personal data.
It's primarily looking at personal data.
Primarily.
But, and also, and again, if there needs to be a carve out, we can discuss a specific carve out, but this idea of, workers having to wear body cameras to track their movements, right? And depending on those movements, pay them accordingly, right? That's and this makes clear throughout the bill that we're looking at the use of AI for this as well, right? The idea that every worker's movement is going to be tracked, there's a difference between that and saying how many chairs can you build in an hour, to how many, restroom breaks are you taking, or how many times are you standing up, or did you drop a tool, right? All of these different things that might start being tracked to determine a wage. I think we've gone far away from the example that you're discussing, right, of how many chairs can you build. This is something far more invasive.
All right, and then on the retail side, I heard the comment that you don't want different people paying different prices, and we're kind of joking here because the Trivago commercial came to mind where the two folks are at the counter, and one guy paid $100 and the other one paid $150 for his hotel stay. Does this impact that type of, it seems like you have to be a smart consumer and shop around. Does this impact that type of pricing?
I'm not familiar with the exact ad that you're discussing, right? But it is the idea that if you walk into a grocery store, if me and you both walk into a grocery store, we should be paying the same amount of money for each product that we buy at that time, right? If we're there at the same exact time buying the same exact things, my bill shouldn't be more expensive than yours. The issue is, yes, we have the brick and mortar examples now, especially with electronic shelving, but Instacart, the issue, they actually ran this experiment where they had all these people in a room buying the exact same products at the same exact time, and people were paying different prices for different goods depending on the data that Instacart had on them. So
does this bill apply only to purchase of goods, or is it also services and the hotel industry and all this?
It expands to services as well, right? So there's an example of Uber, right? If your phone is dying and Uber knows that and your app knows that, should they be allowed to charge you more for a ride because they know that you're desperate? If you're having a family emergency, should an airline be able to use your data on that to charge you more for a flight, right? There's all of these scenarios now that these companies are increasingly having more data. And to be clear, this is not some crazy thing that we're discussing. There's been discussion of how predictions that generative AI, will allow these businesses to make $240 to $390 billion in additional value, retailers specifically. So they're already working on how to gather as much of your data as possible and then exploit it accordingly to charge you more. It's a matter of what protections we have in place to guard against that.
Okay, thank you.
Thank you, Madam Chair. So my question, I guess, is more on enforcement, because this is going to be under the Consumer Protection Law, which has both fines and jail sentencing and so forth. How do we know if somebody violated? You mentioned the hotel. I know we have a whole commercial talks about how one person gets another rate on a hotel versus the other if they use, what's it, Trivago, whatever. So how do we know when they're in violation? How are we going to enforce it?
So great question, Delegate. And I think that the Instacart example in the investigation that really was this grassroots investigation of sorts into the violations at Instacart, it's tough because they have information, they have data and they have algorithms that we don't necessarily have access to. I think it's really going to be a question of A, having these laws in the book, and then B, investigating violations of said laws. I think the ban on electronic shelving labels is an important step in that, because all of these examples that I just discussed that are, on Instacart or on online platforms, that's one thing. But if you're starting to see that in the actual brick and mortar grocery store, that's going to lead to even greater expense for consumers, but that actually might be a little bit easier to track. But also, if we just outright ban electronic shelving labels, that's an important step at preventing them from even being able to do that. So, we have the letter of support from the Attorney General's Office of Consumer Protections. They've analyzed the bill. They've asked for 2 amendments, which again we've drafted in our friendly amendments to make it easier to enforce this by having some of the definitions match existing statute. But they feel comfortable with the bill and with enforcing it. So.
Yeah, I guess the only point is they enforce by, people telling them.
Yeah.
And so that becomes a whole new campaign to let people know to call them, and then where to,
Right.
Saying that they can enforce it and them enforcing it is 2 different things.
Right.
That's all I'll say.
Right. Thank you.
Thank you. So I don't see any questions, but forgive me, Delgado, I had to step out.
No
Could you
problem.
just tell me who your panel is so I know for my?
Yes.
Elizabeth Bobo.
Jane St. Louis.
And Kayla Mock.
I'm sorry?
Kayla Mock, sorry.
Okay. Thank you so much. All right. Next, we'll move on to also favorable Marceline White. Is she here? Okay, she's not here. We'll now move on to favorable with amendment, Robert Enton.
Good afternoon, Madam Chair, members of the committee. Robert Enton, appearing on behalf of the American Property Casualty Insurers Association. Their members write about 71% of the property casualty insurance in the state of Maryland, and I am signed up favorable with amendments. You have Nancy Egan. You have her written testimony, and it's pretty straightforward. I was thinking about it. There are very few regulated industries in the state of Maryland where their pricing is as closely and heavily regulated as the insurance industry. If you look at her testimony, you'll see where it says Section 11306 of the insurance article requires that insurance rates not be excessive, inadequate, or unfairly discriminatory. When we can't just go out and charge whatever we want, all of our rates have to be filed with the Maryland Insurance Administration and ultimately approved by them. So I'm not quite sure, how this all fits in there. But what we would like to have, and we have gotten this in many other bills over the years, particularly that have gone through this committee, would be just an exemption which would say that an insurance company authorized to do business in the state or insurance producer licensed by the state is not subject to this section. And that's typical of the language that we find in other provisions throughout the Maryland Code as it applies to the insurance industry. So with that change, we would have no problem with the bill. Thank you.
Thank you, Mr. Enton. I don't see any questions. Thank you very much.
You're welcome.
We'll now move to the opposition. Brianna January, Margaret Durkin, Grayson Wiggins, Kaylee Locklear.
Good afternoon, Madam Chair, esteemed committee. Brianna January with Chamber of Progress. We are Center-Left Tech Industry Association in respectful opposition to HB 148. We understand the sponsor's concerns, but I think that there is a fundamental misunderstanding of what these tools do and don't do and what this bill would mean for affordability in Maryland. Despite speculation, there is no concrete evidence that surveillance pricing is used in a way that harms consumers. Instead, personal data is regularly used to offer personalized discounts and savings, which, intended or not, would be banned under HB 148. While it doesn't ban demographic discounts like for students or vets, in practice, the bill would ban personalized coupons. You regularly buy the same brand of chips at the grocery store, so the store sends you a coupon for that brand. It would ban loyalty rewards. You buy 5 coffees from a local shop, your 6th is free. It would ban subscription and retention offers. You unsubscribe to a platform and they offer you a discount to resubscribe. It would also ban delivery and rideshare promotions. You regularly buy from the same Mexican restaurant, so a delivery app offers you free delivery for that restaurant. It would also ban new product discounts. The grocery store notices that you buy a lot of energy drinks, so it wants to offer you a coupon for a new brand that it's carrying. That would also be banned. Lastly, small business offers that are used to compete on large marketplaces would also be banned. And for these reasons, similar proposals have been rejected around the country, including in California. Committee, if passed, Marylanders would be the only in the country to face these unique restrictions on discounts and savings, being forced to find savings where savings used to find them. We simply cannot afford that in the state, and we urge you to reject the proposal at this time. Thank you.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce. You have our written testimony that has a longer list of our concerns with the bill. I do just want to point out a few here today. So on page 2, they have defined an automated decision system so broadly that I would venture that it could include a calculator, to be candid with you. On page 3, they have defined surveillance data so vaguely that it appears to prohibit any research on potential hires or market data for price setting. It just seems to outlaw research generally. On page 5, the prohibition on surveillance-based wage setting is drafted in such a way when you read it back through the bill that it appears to prohibit an employer from considering a person's experience when deciding on a salary offer. And so given the broadness and the overly broadness and the vagueness that's included in the bill, we are opposed to it. And then I would, again, just restate that we have our written testimony, which has a longer list of concerns as well. Thank you.
Good afternoon, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are in opposition to this bill. And I want to start by making it perfectly clear, crystal clear, that retailers strongly support the principle that consumer data should not be used to increase prices. And if that's what this bill said, I'm pretty sure I wouldn't be sitting up here. We agree with that goal, full stop. But this bill, and yes, another bill that you will see next week, goes well beyond that. And in practice, it limits retailers' ability to use consumer data to lower prices, even with the attempt at a loyalty exemption. So let's rewind to 2024 and our data privacy law. Our data privacy law in this state allows businesses to collect consumer data as long as we disclose that we're doing that and we allow opt-out. That's what that law essentially says. But consumers and retail loyalty programs are different because they're more protective. They are opt-in. Consumers choose them because they want savings. Retailers use data to deliver data-driven discounts, not penalties. And you heard these examples of coupons. I won't go into that. But targeted offers we use constantly because we want to attract new consumers to us. And I need to add this as well. Importantly, neither the FTC, the University of California, San Diego, nor any state has found actual evidence that retailers are engaging in widespread surveillance-based pricing abuses. So why this legislation now? And I think you just might have figured it out. It appears not driven by consumer harm, but by unrelated issues. union pressure around digital shelf tags, dollar store settlements, and third-party delivery service pricing practices. This bill eliminates consumer discounts, undermines existing data privacy law, and restricts beneficial data without evidence of harm. I'll stop there. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a tech trade association. Thank you for allowing me the opportunity to speak today on House Bill 148. You have my written remarks. I will add that we do not condone the targeting of consumers based on factors such as religion, race, or political affiliation. As others mentioned, we're concerned about the broad nature of some of these definitions, such as surveillance-based price settings. This bill prohibits practices that have been used responsibly to support private pricing and data-driven business solutions to enhance the customer experience and market competition, ultimately lowering prices in some instances. This bill will impact a business's ability to use customer data to generate discounts and promotions. We're also concerned about the bill's private right of action, which is in the legislation. And as mentioned previously, California AB 446 was attempted by legislators last session. Ultimately, that bill sponsor ended up pulling his own bill due to industry opposition. And I will add that in my home state of Pennsylvania, there was a hearing scheduled not once but twice on this bill, and both times that hearing was canceled, and there is no future date on that hearing. So for the above stated reasons, TechNet is opposed to House Bill 148. Thank you.
Thank you. Delegate Adams.
So I'm imagining a scenario where, you had Black Friday, I think they call it Cyber Monday, whatever that looks like, and, these retailers we all like doing business with offer special deals, right? And as you and I are sitting here today, it's early February, maybe we go shopping today for something, and the discount's great, but it's not like Cyber Monday great, right? You guys do that for a particular purpose, and off you go. Wouldn't you be in violation of the law? Like if you had this item that you had on Cyber Monday at a certain date, and then you came back in February and through targeting for means that I would have agreed to, because we passed a law that has me opting in.
Yes, absolutely.
You guys would be in violation of that times how many hundreds of thousands of examples?
Correct. There's no differentiation in this legislation between raising prices and discounts. So we would not be able to use any sort of consumer data to lower prices.
Right. So, aside from the private right of action, which is like the free-for-all that I just, do we really have this problem is what I'm saying. That's.
You're spot on.
Okay.
No.
Tell me about the electronic tags. I need to understand better what's going on in the industry. Look, AI is a thing. I think we're all interested and concerned, but I think for the most part, people are embracing technology, and I'm assuming that retailers are doing this not because consumers hate it, but because, frankly, maybe consumers are getting more out of this than what they got 5 or 10 years ago, information. But tell me a little bit more about what you're after there.
Thank you. I really appreciate that opportunity because ESLs were not included in this bill, so we didn't exactly anticipate this. Good thing I just, in my purse, have laying around some ESLs that we can have a conversation about and talk about what they can and cannot do, because there was an immense amount of misinformation around them. And I think where we should start is in Europe, that is the standard as far as tags go. And the reason is because of their efficiency and transparency for consumers. And we can get into some of those issues that have come up, but I think that's really important because GDPR goes way further than any privacy law that's been passed in the United States. I want to be really clear about that. And digital tags, not one time, have been brought up in Europe in violation of any sort of data privacy practice. So I want to make that really clear. In our stores, so if we use Walmart as an example, because that's come up a lot today, it takes an employee 50 hours a week to change tags out at a single Walmart, a job that, by the way, many employees despise. And these help with efficiency on a level you cannot imagine. The home store nationally makes a decision, they press a button, and those prices change nationally. That's how quick that is. And I also need to mention this as well. There is no evidence of job loss. These individuals are not being laid off. There's no announcements. If you Google it, that just doesn't exist. And when we talk about efficiency as well, on many of these tags, you'll see in the corner, there's this teeny tiny little clear area. That's a light, and that helps them do their job better. So when they go to restock shelves, these puppies light up, and they very easily can find where it is that they need to restock items. So it provides efficiency on a different level. And finally, if I may, as far as what this tech does and what it doesn't do, this is not connecting to your phone. When you bend over and look at an item on a shelf, it's not reading your retina and then changing the price when you go check out. This technology is 15 years old. There are 6 companies in the world that manufacture these products. You will hear from one of those companies next week. They were going to testify today, but I think they're stuck in another hearing in Nebraska. But thank you for giving me the opportunity, because that company will speak to this issue, and it truly is just a non-issue.
So your concern is that the bill is silent on these, but you believe it is brought into this bill?
It will be brought into a bill next week, and they have an amendment that just brought the issue into this bill, should the committee choose to adopt that.
Yeah, because the last thing I'll say is this feels like Groundhog Day, because we've been talking about loyalty programs and consumers interfacing with businesses for years now, and I'm not remembering the politics of how that loyalty program thing landed, but all I can tell you is that consumers ask for it. Businesses are offering it. AI is a new component to that, and a bill like this is almost like, are we scared of technology? Are we worried that there's something that nefarious going on? Is that the instinct that we should have as a legislature, to automatically assume the worst for the purpose of protecting people? And I just not sure I subscribe to that particular
Collecting
philosophy.
data is to lower prices. That's what we do in retail. We want you to come back. We want to create better store experiences. It wouldn't make sense for us to be increasing prices all over the place. And there are cases of bad actors occurring, but I would refer to you to the unfair and deceptive trade practices that could be enforced. And I think there'll be an opportunity to talk about some of those cases here after me.
Thank you very much. Seeing no further questions, thank you to this panel. Our next panel, I'd like to call up Kelly Schultz, Andrew Zirkle, Mike O'Halloran, Michael Adams. And members, for those of you who may not know, this lovely lady before us is ECM alum, Ms. Kelly Schultz.
The best committee in town, Madam Chair. Madam Chair, Andrew Zirkle is also with my team, and he signed up in case we had a conflict going back and forth, so it'll just be me. So for the record, my name is Kelly Schultz. It's great to be here in Economic Matters. Thanks for having me. I'm the CEO of the Maryland Tech Council, and we are here in respectful opposition to House Bill 148. And for most of my testimony, I will say me too to the last panel, because she's a lot smarter on this issue than I am. However, I will add a couple of asterisks and say that we would also like to work with the bill sponsor and perhaps the committee and legislators on what could be perceived as harmful standards when it comes to consumer innovation, when consumer prohibitions on their data being utilized. But we do believe that this bill probably does not clearly distinguish the terms in which those practices are being utilized or how they can be deterred. And more broadly speaking, this is after the Me Too, the uncertainty of bills like this in a particular state really do have the negative benefit for investors when we're talking about the innovation community and the growth in technologies, especially in advanced retail technologies, that we are able to utilize as far as investments in growth and innovation. So short and sweet, we will say that we oppose this bill as drafted, Madam Chair. Thank you very much.
Good afternoon, Madam Chair, members of the committee. Michael Adams on behalf of the Maryland Retailers Alliance. I will also be brief because I think the last panel did a very nice job of summarizing the issue. The point I wanted to make, though, is HB 148 is seeking to ban a tool. AI is a tool, and the significant advances in pricing systems that it is being used for allow retailers to lower prices. The tool is not the issue. Data being applied in an unfair way is the problem. These practices are already prohibited by Maryland Commercial Law 13301, which prohibits unfair, abusive, or deceptive trade practices. Simply taking away technology does nothing to protect consumers and simply makes retail less efficient. And with that, I would answer any questions. Thank you, Madam Chair.
I don't see any questions for you two, so thank you very much. And it looks like we do not have a virtual witness. So with that said, that concludes the bill hearings on House Bill 148. That concludes the bill hearings for today. Members, I will just give you a gentle reminder in your emails. We do have a joint event this evening at 6 o'clock. You're encouraged to attend if you cannot understand, but heavily encouraged. We are adjourned.